Good afternoon, commissioners, and good afternoon to our 116 stakeholders that are joining us this afternoon. It is 1 o'clock. I am Jeff Robbins, Chair of the Commission of Colorado Oil and Gas Conservation Commission, and we are going to reconvene our rulemaking meeting this Friday afternoon. Wahoo, Friday afternoon, that's a good thing. And I want to start by potentially, and I hate to do this, but potentially moving us backward just a little teeny bit on one issue. That issue is on the, I feel like maybe I did a poor job of not having us fully air out the issue around sort of the biological resource issue. And I want to perhaps call on Commissioner Nanjapa, this is in her wheelhouse. Do you want to sort of frame this issue for us and sort of, give me some perspective on where you are? It's an important issue, and I felt like perhaps in moving to conclusion, I did a poor job on it. So, Commissioner Nanjapa.
Thank you, Mr. Chair. I mean, first of all, I don't believe you did a poor job. I think we discussed kind of this issue. It came up in a couple of different ways. And I guess just in my mind, as we've mentioned, there are many of these types of issues like definitions that pertain to multiple areas of the mission change rulemaking. So in my mind, I have planted a mental flag that biological resources is something that we may need to keep thinking about and considering and potentially further defining. And I know we do have, some of our stakeholders who have provided the definitions or suggested definitions. And I think in particular yesterday, when we heard from the Wildlife and Biological Resources Council, I asked if, I mentioned that I didn't see the specific definition for biological resources in their pre-hearing statement. And they said that they may have submitted it with the 1200, which I looked back and it looks like that is the case. So in my mind, these issues are gonna keep emerging, probably also in the 5 and 600 series, or especially in the 600. So I think we're gonna continue to have conversations. And so I didn't want to get too narrow on this yet. So that's kind of where I was coming from on that perspective, but I appreciate the chance to kind of share where I was coming from on that.
Great, thank you. And I'm glad we were able to have that discussion. I agree. I think this, as with, for instance, alternative location areas and the criteria and the numbers and the distances, these pieces of these puzzles fit together, sometimes good and sometimes bad. So I think you're right that we will get back to that. Okay, with that, I think we were planning on moving to the, I'm just going to turn it over to Director Murphy. I think we had a few discrete issues that we wanted to focus in on in hopefully 15 minutes, and then we would be potentially done for now on 300 with direction to staff to come back with some solutions, and then we would reconvene on it later next week.
Thank you, Chair. So of these 5 issues, I think I would suggest that we start with lesser impact areas, because I think that's probably the most kind of robust or nuanced topic, and some of the other ones feel a little bit more targeted, and then move into the proximate local government. And for the life of me, I can't remember the context of the issue being raised. And then we can close out talking about public comments on the Form 2 or the application for permit to drill, the question of local governments having the ability to request an extension of public comment period, and then the notice to water rights holders. I have staff's perspective on 4 of those and can share that either now or as part of the dialogue with the commissioners, whatever you prefer.
I would suggest you give us staff perspective on each area, and then we can debate them in turn. So what staff think about lesser impact areas?
Staff, the lesser impact area concept was built in to allow some discretion to consider development that doesn't have the same footprint, if you will, as in multi-well pads in the DJ Basin. And so in some circumstances, especially rural, outside of sensitive areas, whether that's sensitive for wildlife, water resources, et cetera, having the flexibility to tailor the plan to the impacts of the proposal made sense to staff. Of course, it still retains the opportunity for the commissioners themselves to say, nice try, guys, but we actually do need this piece of information as well. So that to me is the thinking on it, the purpose for it, and also the sideboards around it. It doesn't let me run wild, thank goodness. And I think, you know, one of the themes that I presented for staff in evaluating rule changes is what is the appropriate balance of decision making between the commission itself and the director. And so this is a place, as are so many others, where the commission can weigh what decision it wants to make versus delegated to the director herself in this instance, themselves in perhaps a different instance. So that's lesser impact areas. Because I don't explicitly recall this, what the proximate local government question was, I will be able to respond to it once we tailor that question. On the Form 2 public comment, staff has tried to move the public comment process and the decision-making process into the oil and gas development plan context, and providing robust public comment periods in those spaces so that someone wanting to submit a public comment that had concerns about the subsurface development could do so, and staff could consider it on the front end. And you know, the Form 2A itself acknowledges a number of wells and that are proposed, and so that could help help shape our consideration of it. I think we do have a lot of expertise in the Form 2 space, or the application for permits to drill, and so we want to kind of truncate or absorb public comments on the front end, and then the way it's developed today would allow the APDs to go through at a more administrative level. On the local government expansion of the public comment period, the rules as crafted grant the director the discretion to extend a public comment period as is reasonable for 30 days. To me, that is inclusive of local government's request for an extension of the public comment period. I think that would weigh very heavily on my mind. If we want to build in a more formal acknowledgement of that, that's a-okay. Lastly, on the notice to water rights holders, there's a pretty robust discussion of this in the statement of basis and purpose, and I can't remember what page right now, but I think that what we want to kind of reiterate is that this is a really complicated space, and our sister department or division within the Department of Natural Resources, the Division of Water Resources or State Engineer's Office, has a system built in to work through water rights issues, including the authorization of use and the purpose for use. And so an operator must navigate, and I don't mean that pun, but it's a great one, that system before using the water. And so we want to be complementary to their efforts in that space. And I think that the question of notice to water rights holders kind of sets up our next conversation on the 500 series, in that a water rights holder who had concerns about use of water could always come to us as an affected person to bring a concern to our attention very formally to the commissioners. They could also seek notice of any oil and gas development plan, seek to receive notice of any oil and gas development plan. So I think we have some tools available to it. And as one of the parties or stakeholders noted yesterday, it's identifying exactly who is to receive notice is complicated and difficult, so it would be hard for us to manage. So I think those are the 4 issues, and that the discussion of the notice to water rights holders is addressed on page 52 of the statement of basis and purpose, for anybody who's just dying to read a couple paragraphs.
Thank you for that overview, Director Murphy. Did your overview encapsulate anything that AAG Minor would have also added? I know he's did you want to add anything, Mr. Minor?
You can always say it better than I can. So.
No. Okay, great. Okay. Rather than start in on this, I'd like to defer to commissioners. Do you guys want to pick a topic and provide perspective? Commissioner McGowan.
Oh, thank you, Mr. Chair. I think the Form 2, I'm looking back through my notes. I think I brought it up, and I think it was during Adams County's, oh, sorry. Now I lost my notes. I think it was during their presentation and their public testimony that they wanted to see, they believe that Form 2s should be allowed to have public comment before approval or denial and should include the local governments and the public. They were also the folks who wanted kind of, I think, an expanded opportunity to ask for, to actively ask for consultation and to ask for an expanded comment period. So I think, to me, those are all kind of lumped together. And I just thought I'd make sure we put them up for discussion.
Director Murphy, on the Form 2 public comment piece, or maybe this is for AAG Minor or Jane Stanzik, but under the wellbore spacing unit that may end up in an approval, is that still just a Form 2, or is there a Form 2A with that, or am I all out in left field, Attorney General Minor?
I can answer that, Mr. Chair or Director Murphy, but the wellbore spacing unit is now handled just like any other type of drilling and spacing unit application pursuant to Rule 305. So that would come in with the broader oil and gas development plan package and not be considered in conjunction with the Form 2, which is just limited to the application for permit to drill for downhole issues.
I guess and thank you for that. And I guess what I was trying to get at is the staff pivot of no public or all public comment coming in at the ODGP, is there something that we may be missing where the Form 2 is somehow or another reviewed administratively, but the public's never had a chance to comment? There's a question mark there.
That's fair. Again, I think staff's purpose is to really focus public comments at that first decision-making stage on the OGDP. It allows for more efficient review of the Form 2s, which is important in 1041 areas where we're on a more specific time clock. But I also, and historically, most of the comments we've received on Form 2s have really related to surface impacts. As compared to like the deep downhole, you're going to actually commingle these two different formations through this development plan. And so I think that being able to look at the proposed spacing, look at the proposed surface development, we have eyes into and information out there for folks to see the proposal. But I also understand the importance of transparency in this space. And so again, we would like to get all of the comment we can early on to be able to evaluate it kind of on the front end, right, with the spacing and then with the surface development plan. But
okay,
that's why we structured it this way.
Thank you, Director Murphy. I mean, I'm one vote that's sort of in favor of leaving it as is, and you know that we focus our public on public comment at the appropriate time, which is at the OGDP. Do other folks want to weigh in on that topic?
Yeah, Mr. Chair.
Commissioner Gonzalez.
Yeah, I kind of second that recommendation about leaving it as is. You know, when it comes to the Form 2 and just downhole implications of which public may have comment on, it's just a super technical endeavor, right? Operation that's being permitted under that form. The impacts to public health, safety, welfare, the environment, wildlife resources are much more tied to the above ground operations, the spacing for correlative rights. When you start getting into the technical aspects of how the well is going to be drilled downhole, I think that's between the operators and the professionals here at the commission staff to really evaluate that. I'd be really, surprised if there was, technical arguments through a public comment for Form 2 that could not otherwise be addressed through the 2A or through the DSU application, otherwise in that whole OGDP package. So that's my 2 cents on the matter.
Anyone else with thoughts? Okay, going once, going twice for leaving it as is. Sold. Okay. You wanted to talk about, did we want to talk about proximate local government and what was the issue there? Director Murphy? Sorry, I know you just want to, so I've already forgot.
My vague recollection is that it relates to consultation or early consultation, and perhaps it was Commissioner Nanjapa who raised it. But if I'm putting you on the spot, Commissioner McGowan.
It was me. Sorry, all these little leftovers are mine. So I think that was a comment and a request to include proximate local governments in the consultation process.
Mr. Chair, is that to expand beyond just the notice and create more of a formal, I guess, process for consultation? Is that where you're getting at, Commissioner McGowan?
So thank you. Sorry, Mr. Chair. I think
Go
if
ahead. I'm eating lunch.
I see that you're eating lunch. I think if I understood, and maybe folks can help me fill in the blanks here, that the proximate local government, there could be benefit by the proximate local government that's affected by activity to participate in the consultation process, so they can hear what's going back and forth between the relevant local government. And I wonder if we're problem solving further upstream during consultation if they're allowed to participate. I don't know if I understand the process completely enough to understand if that would be valuable in a positive way or not. But that's what I heard, and so I thought I'd put it on the table.
Mr. Chair, if I may try to provide some background about perhaps the context and the rules where this would come up.
Yes, Mr. Minor.
So in Rule 302G, which is the general local government consultation provision, that does already include the option for approximate local government requests to be included in the consultation. So I believe what parties brought up during their presentations was that currently in Rule 301F2, which is the sort of pre-application consultation between commission staff and the local government in a sequential permitting process, proximate local governments are not currently included in that rule. So I think that was sort of the context of the parties' feedback.
Thank you, AG Minor. That's helpful.
Yeah, that puts a pin in it. Commissioner Nanjapa.
Yeah, thank you, Mr. Chair. I think I also kind of raised this as well in a slightly different context, but around the same idea that earlier in the process, if there was an inclusion of the proximate local government, and especially in my mind, it was where the proximate local government rules, if they had more stringent application of this, their citing decisions that differed from the jurisdiction in which the actual location was taking place, if that makes sense. So I think that's where having this a little bit more formalized or just part of the process would allow the proximate local government to engage and then potentially even, more directly engage with the other local government. But it seems like that would be an area that would be, especially from our purview, most protective for public health, welfare, safety, and the environment when we can engage them.
Commissioner McGowan.
I wouldn't mind Commissioner Mesner's kind of perspective on this. So I know that local governments feel protective about their processes and the way that they put things in place and work with their own constituents. And I think that, to Commissioner Nanjapa's point, if you involve your next door neighbor earlier in the process, is it easier to address issues, especially if you view solutions in a different way? But then I also understand that folks are protective about their what they have purview over. So I wouldn't mind Commissioner Messner's kind of perspective.
Sure, I'm happy to chime in. I mean, there's a few different situations here. So, I mean, you've got proximate local governments where you've got municipalities within a county, right? And so those proximate local governments, you know, have different relationships, but then you've also got proximate local governments where you've got, you know, a county and a county bordering one another. And then you've actually got situations where you've got a municipality that crosses 2 or 3 different counties, and you've got all of that interaction going on there. So, I mean, this is a complicated thing. There's certainly strong feelings about, you know, whether or not there should be, you know, any ability for a jurisdiction outside of yours to have any input as to what land use decisions may be made within your jurisdiction. However, there's also lots of communication that happen, particularly within counties and municipalities, where there's MOUs, there's IGAs, there's MOAs, you know, trying to determine how land use is going to be dealt with in those transition areas between unincorporated county and municipality. And so these things all happen, right? I mean, this is all happening. And then there's situations where the municipality and the county, you know, just don't get along at all. And there's no IGAs, there's no legal anything, and it's a little bit of a free-for-all, right? And so I think what the intent here, the way I understand it, which I think is good, is that, you know, in a situation where you've got an application that is in one jurisdiction that could potentially impact residents in another jurisdiction, that there should be some notice and there should be some consultation. And I think that the rule as written right now does provide that. Ultimately, you know, the decision-making, well, in this situation, we're reviewing it for the state and to make sure that we are being protective of public health, safety, welfare, the environment, and wildlife resources in our review process. And so we need to look at it more holistically than a local government would have the authority to be able to review. And so I do think making sure that we are taking input from any affected or impacted resident or environment, irregardless of jurisdiction, is important for our review process.
You know, I went back and I just read the rule. And so as Attorney General Minor mentioned, that under 302G, when there's an application to the commission, we do have proximate local government consult if it's within the area proximate. But the rule that was asked to have additional pre-app is 301F2, and that's the situation where there's not an application at the commission yet. And instead, there's an application at a relevant local government, and we've created the opportunity for the operator to provide us with notice of that application so that the commission staff can early on be engaged. I don't think it's appropriate for us to tag along or require this volitional act of the operator to also bring in the proximate local government when this is an application to a local government. I think that's us telling local governments how to do things, and that's what we've been trying not to do. I also think that we should rely on our local governments and the processes that they have to engage with their neighbors. So I think that staff's got it right. When it's at the commission and it's a permit at the commission, we will engage proximate local governments if that's applicable. I appreciate the nuance of the way it's drafted now that allows the operator to engage and the relevant local government to engage with us early before the application's with us. So I kind of like the balance that we have right now. I'm seeing nodding of heads in an up and down fashion. So I'm going to suggest Commissioner Gonzalez.
Agreed.
Okay. All right. Notice to water rights holders. Let's go to that one. And I would start the discussion here is that, is this a problem that needs solving? because in my 18 months doing director review of permit applications, I don't remember this being an issue. So that's a question for staff. And then my only other thought is, while I like notice, it seemed to me like it would be a difficult proposition to identify water rights holders to generate the notice. So those are my 2 cents. Seeing silence, maybe we're just going to say that we don't need to address this one. Commissioner
Well,
Mester?
I think you asked a question of staff, and so I was waiting for staff to answer, but I can chime in, but I would like staff to answer that question.
Director Murphy? Or Mr. Geronimo?
Chair, I would say that the staff didn't propose it in its rules because I think we're striking the right balance. I think that there are other mechanisms in place to support and protect water rights holders, and we're working in complement to the work being done by the Division of Water Resources. Clearly not every party agreed with staff's position on that, and that's why this issue has come to you. And so I'm walking a fairly fine line here, but want to acknowledge that we think that there are tools available to water rights holders to ensure their protection, and we've built into our rules a number of substantive protections around water in general, water use, water quality, et cetera, that protects the media itself. And there are mechanisms to appeal to you directly as commissioners. There are mechanisms to work through the Division of Water Resources. And so we have believed that that is very protective of public health, safety, welfare on this front.
Mr. Chair, if I can just add one thing about staff's position to what Director Murphy said, which is absolutely true on the substance, just about the procedure. At the request and great feedback of many stakeholders and parties, staff has added provisions that allow any person to sort of opt in to receive notice of commission hearings, which would include notice of permit applications. So there's sort of a now opt-in system where anyone can sign up to just get an email list with notifications that Ms. Larson can discuss more when we get to the 500 series here in a few moments. And that system is great because it does mean that if there are water rights holders who know that their interests might be impacted in a certain area, they have the option to opt in and find out when there's something that might affect their interests happening. And then of course, with the broadened definition of affected person that we will also hear about in the 500 series soon, those water rights holders, should their interests in fact be implicated by a proposed oil and gas development plan, would absolutely be able to demonstrate that they were affected persons and participate in the commission hearing process as appropriate.
Commissioner Mester?
So I appreciate that. And this is one of the topics that was important to me, but I do actually acknowledge and appreciate the ability for water rights holders to be able to opt in for notice. And I think that's an important piece. I also acknowledge what Mr. Baumgarten said yesterday in testimony, that it is very difficult to find water right holders information in order to be able to notice them. And so I think this is a good compromise. I think that the piece to understand here for folks that may not know, but actually in this picture behind me, which is of the Ohio Creek Valley in Gunnison, that's a ditch, an irrigation ditch right there that feeds our ranch. And that takeout from the creek is 5 miles up valley. And so that's kind of the catch where, if you're looking at proximate to a particular pad, that may or may be impactful, but it could potentially affect a water rights user that's 5 miles down the irrigation ditch. And so, but I do acknowledge that I think the system now that we have in place does accomplish that notice piece, so that if someone wanted to be involved, they certainly could.
Others with thoughts on this issue? So it seems like the sort of implied spot is we leave it as is and try it out and see if the sign up for notice is a mechanism that can work. Okay. What's left, Ms. Murphy?
Two pieces, the lesser impact areas and the local government expansion of the public comment period.
And I think on both of those, you and staff sort of feel like you're in a good spot, that the lesser impact areas is a good tool for you, and that there's already an ability for expansion of public comment just in general, and that you would use your discretion wisely in that regard. And if you hear from a local government, you would probably do that. I'm comfortable. If commissioners feel we need to do more in either of these areas, please raise your hand and I'll call on you. Seeing no hands raised, I think we have made it through our issue list of 300 series. With that, we have given direction to staff on the 300 series. Staff, I'm sorry we give you homework, but you do great at it. You always pass the test. So we'll look forward to receiving something back from you consistent with the direction that we've presented you. And then once we get that and have a chance to sort of think about that, then later next week, we will halt our proceedings around 500 or 400 if we're that far, and come back to 300 and hopefully land the 300 ship in a good conceptual place. I want to thank all of our stakeholders who have presented on 300. We had a lot of information, a lot of witnesses. I also want to thank stakeholders, staff, and others for the wonderful amount of agreement that was reached and sort of harmony and collaboration. I'm excited to turn this system on and work with local governments with their regulatory regimes and our new regulatory regime. But before we can do that, we got to go through 500, 400, 600, and 200, and then 8, 9, and 12. So with that, I don't think we should take a break. We should probably plow right in. I gave Hearings Officer Larson the heads up that we were going to be calling upon her. She magically appears in the left-hand corner of my screen. So with that, Ms. Larson, we will move to 500 series, and we look forward to your presentation.
Thank you very much, Mr. Chair, and please let me know if you're having troubles hearing me. So I will share my screen. We have a presentation to present to the commission, and we'll start with Director Murphy. She'll give us a brief introduction here. There we are. All right, Director Murphy.
Thank you, Mimi. So, sorry, I'm like having a little bit of shell shock, kind of trying to shift gears here from how do we permit to how does our commission hearing process function and operate. And this is an arena in which we've received really focused and important feedback. And I think on one of the pieces that's most important to me is access to a process. And one of those components is redefining affected person. And to, in my estimation, broaden the categories of persons that can come forward to this commission. And importantly, I think that the definition proposed and being considered in staff's definition aligns with the definition of affected person set forth in the Colorado Administrative Procedure Act. And I like the idea of aligning with the benchmark in Colorado for how to provide process in the administrative realm. I think that some of the other pieces that have gotten a lot of attention is the question of variances and how will we process variances. This is critically important because we're adopting rules to set the expectation. Deviating from those should be done lightly. And so what staff has proposed to you capitalizes both on your expertise as full-time commissioners and the directive of 181 in that the commission itself must hear variance requests that implicate public health, safety, welfare, and the environment in Rule 502. In Rule 504, we've broadened and provided better notice in my estimation. And I think that, again, when we talk about things like access, transparency, and improving our accountability to the public, things like notice are critical to that. So Rule 504 heads up is notice. In Rule 507, again, it's about broadening and creating access and transparency, and establishing how an affected person can petition to participate as a party. Rule 511, this to me is like one of the most important tools available to commissioners as staff has proposed. And so I would encourage you to think hard about it. I think in many of the public comments and party testimony that we heard was this question of how do we engage the commission in what we're doing? How do we educate the commission about our community, our issue, our this? And to me, Rule 511 provides that tool. Historically, the local public hearing process was arcane and was predicated on a development style that no longer existed for oil and gas. And so it necessarily boxed out so many of the conversations that were requested. And so it is now at your discretion to choose when to engage on any topic after a formal request through 511. I would want to like flag one piece. I think that one of the public commenters maybe suggested that any person can mandate a commission hearing, and that's not quite accurate either. It's that any person can petition this commission to come have a public hearing, and you have flexibility to respond accordingly. And I think the last rule I want to touch on before Mimi actually takes you in detail through how these rules will work together with the other provisions and within themselves is Rule 526, and this is the responsible party rule. It has gotten a lot of attention from lawyers in particular. To me, it affirms that the director has the burden to prove allegations in a notice of alleged violation. And I think that that's the right space. That's exactly what AAG Minor articulated about an operator applying for a permit, right? The person requesting a commission decision bears a burden of proof. And in the instance of enforcement, it is staff that bears that burden of proof. However, if an operator is responding to say, no, it wasn't me, the operator then bears that burden of proof. And so again, I think it appropriately balances who is proving what and is consistent with the act, but I probably should steer away from getting too lawyerly because I am no longer a lawyer. I'm sitting here in a very different space and would ask that you also engage your counsel or AAG Minor on questions around kind of legal piece as it arises. Again, I feel very strongly that the responsible party is consistent with our act and sets forth the appropriate balance. So with that, I've gotten a little redundant or repetitive, and I would ask Mimi to jump into the nuance and the details and the specifics.
Thank you, Director Murphy. Let me see if I can actually advance my slides. There we are. So as Director Murphy outlined for you, we will be discussing this afternoon the 500 series. I'd like to start briefly with a brief overview of who I am. I am the Hearings and Regulatory Affairs Manager here at the Commission. I started at the Commission in December of 2018. Prior to that, I was an Assistant Attorney General who represented staff here at the Commission. And prior to serving in the Attorney General's office, I was in private practice representing clients and interests related to natural resources law. So I've been fortunate to have a varied career and very fortunate to be here at the Commission right now. The hearings unit itself, for members of the public who aren't familiar with us, we work with the Commission itself. We are an arm of the Commission. We're not technical staff, so we are separate. We're made up of hearing officers, and we work through the applications that are filed with this Commission. And how those applications are filed is addressed in the 500 series. So the 500 series sets out the procedures and policies for appearing before our Commission. As part of the 500 series, the Commission will meet, they will adjudicate applications that come in and issue orders. Those orders can, in fact, override a rule. They can have findings that may be different from a rule in our rule series. I think there was a question earlier this week with respect to comprehensive area plans in our current CDP process. and if the commission had leeway to, at times, deviate from what a rule might provide or what something might provide in our CDP rules. And the answer is yes. And that happens through a commission order after a full hearing in front of the public. So when staff was going through Senate Bill 19181 and recognizing the efforts that were needed in order to reform its permitting process, it was clear that we also needed to look at the 500 series and see how the 500 series needs to be reformed in order to facilitate the new unified permitting process that you heard about earlier this week. So the 500 series rules that I'm going to walk through today will focus on how we have sought to reform the 500 series to accommodate this new unified permitting process. And importantly, how we are seeking to increase transparency and facilitate a more meaningful public involvement. It's important, we have heard prior to 181 and certainly through 181, how important it is to ensure that the public, that their voice is heard and they have the opportunity to participate in our processes. So that's what our rules are seeking here to do. So starting with the 300 series and the unified permitting process, the proposals that we have in the 500 series really seek to complement the 300 series process. So if we just want to start with how you file an OGDP. So within the 300 series, we have Rule 303A1, and that provides what elements of an OGDP operator needs to submit to the commission in order for that application to be complete and valid. In addition to Rule 303A1, we have Rule 503G1, and the Rule 503G1 complements the 300 series and provides that only an OGDP that meets the requirements of Rule 303 will be heard by the commission. So upon receipt of an OGDP application, hearing staff will review that application and ensure that the necessary elements that are required in Rule 303A1 have been submitted. Hearing staff is not conducting a substantive review of the application at that point. It really is just going through hearing staff and ensuring that all the components of that plan have in fact been submitted. Once that sign off occurs, once staff is satisfied that the operator has submitted everything that it was necessary, we'll then issue a docket number, and that application will be assigned to a hearings officer just to start the background processes, making sure that notice is proper and all the boxes are checked and all the necessary things are happening. Another important element of the 300 series that corresponds to the 500 series is Rule 303A7. Under that rule, an operator has to submit a Form 2C, an OGDP certification. That Form 2C will include a certification from hearings or a certification from the applicant that it has submitted the OGDP through the hearings unit. So staff internally on the technical staff side, permitting staff, they know that the applicant, the operator, has gone ahead and actually submitted a hearings application with the hearings unit. So that's important for technical staff to know, and also for the hearing staff to be able to check in and see that, you know, the application is progressing and is moving along. So notice is a really important element of the work that we do here at the hearings unit, and is a very important element of the new OGDP process. Every application that is submitted to the hearings unit must be noticed for public hearing. So what that means is if we receive an application for a pooling matter, a drilling and spacing matter, enforcement matter, we will prepare, we the hearings unit prepare a notice that is made available to the public so the public can see when the hearing on that application will commence. So now that we have the OGDP process and the commission is designed to be hearing those OGDP applications, we will have to make sure that those OGDP applications are noticed for hearing and those notices are made available to the public. Rule 504B1 requires that notice of an OGDP be served on everyone that's identified in Rules 303D2 and Rule 303E1. So 303D2 identifies relevant local governments, proximate local governments, and various state agencies such as CDPHE as being required recipients of a notice of an OGDP application. Rule 303E provides that mineral owners, surface owners, tenants, residents, emergency responders, and others who are within 2,000 feet of a working pad surface, they have to receive notice of that hearing application and notice of that OGDP. It's important to note that under 303E, if notice is sent of that OGDP is sent after the director issues its completeness determination, then, and there are material changes potentially to that OGDP that occur, the operator may have to re-notice its OGDP. So what that means is staff under the 300 series, once they receive an OGDP application, they will conduct a review and issue a completeness determination. That completeness determination is not the final determination on that application. My understanding is, and technical staff can speak to this more fully, but that completeness determination, again, is to ensure that all the necessary elements of the OGDP have been submitted and staff can begin working the application. So once that completeness determination has been issued, we are made aware of it, the hearings unit's made aware of it by staff filing that completeness determination in the record, in the file that we have in the hearings unit. And that's assigned to us, to the hearing staff, to complete the notice of hearing and get that notice of hearing out to those people that are listed in Rules 303 as needing, requiring to receive notice. So if that completeness determination is done, notice of the hearing goes out, and then a significant change to that OGDP is made by the operator. Potentially, we're going to have to re-notice the hearing, essentially start over, because we want to ensure that the public and everyone who's interested in this OGDP application has the most current information and understands what is out there and what's happening. So that's an important element of this too, to note. So once hearing has been completed of an OGDP application, once technical staff has gone through its review, has worked with the applicant on this application itself, the Rule 306C provides that the director will issue a recommendation. And once that recommendation is issued, a hearing on that OGDP can proceed. So right now, under Rule 307A, the full commission is presumed to hear all applications for OGDPs. Our 500 series provides that any application that is filed with us can be heard by the full commission, administrative law judge, or a hearing officer. But again, under Rule 307A, it's presumed actually that the full commission will hear that OGDP unless the full commission determines that they're going to delegate hearing of that application to an ALJ or to a hearing officer. We have taken into account and acknowledged that there are going to be OGDPs that are contested, meaning someone, a member of the public, perhaps another operator, perhaps a state agency, a relevant local government, some entity may object to an OGDP. So if that OGDP application is contested, then that application will be heard in accordance with our Rule 509. And Rule 509 walks through the elements of a contested application. It acknowledges, how a hearing is to be conducted, provides that it will be done in public, and allows for there to be written decisions along the way and final written decisions at the end of that hearing process. And if an application is not contested, so if it's uncontested, then that application can be heard in accordance with our Rule 508. Rule 508 allows for applications to be decided, a recommended order to be issued, and those recommended orders are presented to the commission as part of our consent agenda. So folks may be familiar with our consent agenda process. We had consent agenda actually here on Monday, where there were a number of orders that had been recommended for the commission to approve, and the commission votes on those recommended orders, and if they are approved, then they become a final order of the commission. So we would allow for that same process to apply to an OGDP application. So in all the work that we've done here in the 500 series to create a process that complements the 300 series OGDP plan and the unified permitting process there, we sought to ensure that we're transparent, that there's an opportunity for the public to come in and to participate, and that along the way, people are made aware of what is happening with our OGDP applications. So now I'd like to get into some additional rules that we believe are noteworthy and would like to present to you and highlight how these rules really help to continue to facilitate public participation and transparency. So we have a current rule, Rule 502B, that provides variances may be sought by an operator to any of our rules, and that variance can in fact be granted by the director. It also allows for a variance to be granted by the commission itself, but the director may grant any variance that is brought to it by an operator. There has been concern raised by stakeholders that that is not a good process, that it's not necessarily transparent. And so we have proposed a revision to that. We are proposing a new rule, 502A, that in 502B, where we're breaking up the variance process, meaning we still allow for the director to grant a variance, but those variances that the director would grant would only be ministerial in nature or procedural. So an example of that may be if we have a rule that requires an operator to file a certain form within 72 hours of an event, and the operator, for whatever reason, for good cause, is unable to meet that 72-hour deadline, they could come to the director, request a variance, and say, I'm unable to meet the 72-hour deadline, but I can get this form to you within 5 days. And that would be within the authority of the director to grant that request. We would not need to take that to a hearing in front of the commission. It would be granted by the director. Then what we propose to do under a new Rule 502B is to set aside variances that would implicate public health, safety, welfare, and the environment, and have those variances only be heard by the commission itself. Because now with the full-time commission, not only do we have the capacity to have a sitting body hear those requests, but we recognize that these are important questions, and important questions that should be heard in public and heard by the full commission, and those decisions made by the full commission and not the director. And I think it's important to note that having this distinction between ministerial variances and then variances that implicate public health, safety, welfare, and the environment is not uncommon. And in fact, we have other agencies within the Department of Natural Resources that also have a similar system, in that, for instance, the Division of Reclamation, Mining, and Safety the Colorado Water Conservation Board staff. Their rules provide that the staff, through their leadership, are able to grant ministerial variances on certain issues. So what we've sought to do here is really just to ensure that our rules complement and implement a similar strategy that other agencies have in place. Moving on to affected person. As Director Murphy noted, this is one of the more interesting issues that we have been addressing through the reform of the 500 series. Currently, under our Rule 509, we allow for what we call protests to be filed once an application has been submitted. The protest provisions that we have in our current rules can be limiting. We identify only certain persons who may be protestants in certain applications. So as a bit of background, we have had over the last 2 to 3 years quite a bit of activity of protests coming in on drilling and spacing unit applications. And we've heard protests from mineral owners, which our rules provide for. If you're a mineral owner, you can protest a drilling and spacing unit application. We've also heard from affected surface owners who may not, in fact, be a mineral owner who seek to protest a drilling and spacing unit. Our rules would not allow, our current rules would not allow for a surface owner or someone who believes they're impacted by a drilling and spacing unit and the proposed oil and gas operations to actually protest that drilling and spacing unit application. So that's an example of how our rules can be limiting as it relates to a protest. So recognizing that we want to ensure greater public participation and ensure that those individuals who are most affected by oil and gas operations have an opportunity to participate in our hearings process, we sought to redefine who can in fact petition in to protest an application. So what we've done is we have set a definition for affected person. And we have provided that if you are an affected person, you may come in and contest a hearing application. So an affected person is someone who may be adversely affected or aggrieved by an application. So what does that mean? What is adversely affected or aggrieved? Well, if someone believes that they are adversely affected or aggrieved, what they need to do is they need to file with our hearings unit a statement that first explains what their interest is in the activity that's being proposed in the application. So using the OGDP as an example, that person who feels they're an affected person would have to explain to us what interest do they have in this OGDP. Second, the person would have to explain how that interest could be injured if the oil and gas operations that are proposed under the OGDP are permitted. And then finally, that person would have to explain why that interest is unique to themselves and is not an interest that's held in common with other members of the public. So, for instance, if you happen to be a parent of a child that is goes to school within 2,000 feet or less of an proposed OGDP, oil and gas location or working pad surface, that parent could petition and say that they're an affected person and explain what their interest is and why they feel that they need to participate in the hearings process. It's important to note that we have specified that if you have a common interest with other members of the public, that alone is not sufficient to allow you to come in as an affected person, to come in and protest that application. So, for instance, we can all recognize that we have the common interest of climate change. But if that alone is the only interest that someone brings forth in their petition, that they have concerns about climate change and how an application is going to impact climate change negatively, that alone would not be sufficient to grant that person affected person status. There would need to be something more that actually ties that person to the activity and allows them to advocate as to why that interest is being harmed. Another rule I'd like to discuss is the local public hearing rule. As Director Murphy noted, we have currently under Rule 508A, a local public forum process. That process is, and I won't go into great detail about it, Byzantine. It's quite complicated. It ultimately would allow a local public forum to be held where the director or the director's designee would attend and listen to public concerns. To get to that point where one could actually have that local public forum held, it's challenging. And ultimately, it's the director or the director's designee who attends. Our rules don't require that commissioners attend. They are also not prohibited from attending, but the expectation is that they would not have to be there. So in order to ensure that we are giving a voice to the public and allowing, again, for greater participation and greater transparency into our processes, we are proposing a new rule, Rule 511, which we're calling the local public hearing rule. So under Rule 511, we want to have feedback from the local community members and local government staff and elected officials about an OGDP. So any person could request that the commission hold a local public hearing. And that local public hearing could be requested by members of a disproportionately impacted community, a homeowners association, a school. We don't limit who has the opportunity to make that request. We want to ensure that the commission itself is there at that local public hearing. So we've provided that in the rule that it is the commissioners who would participate there and listen to feedback from members of the public. Importantly, the commission itself has the discretion whether or not to grant and to actually hold a local public hearing. We elected not to make it mandatory for a couple of reasons. First, the commission does need to have the discretion about when they hold a hearing and where. That's important. Secondly, if a request comes in and potentially it is a OGDP application that hasn't been protested, has not been contested, there still may be important issues that the commission wants to hear about, but the commission elects to maybe have this hearing remotely, meaning the commissioners are here in Denver and the interested persons who have requested this hearing are, many counties away. We could do that. That would give us the option to potentially have this remotely. We wouldn't necessarily have it in that local community. So again, just making sure that the commission has the discretion whether or not to grant the request and when and where to hold it is important. So we did leave that in this rule. It's not a mandatory requirement that the hearing occur once it's requested. Moving on to rule, another noteworthy rule, Rule 510A. So our current process for hearing from the public is governed under our Rule 510. You will see in orders for rulemaking, for instance, our case management orders that come out, we will note Rule 510 statements will be taken on this day at this time. So the Rule 510 statement is the public comment portion of our rules and how we receive that public comment. An element of our current Rule 510 is it requires if a member of the public wants to make a comment at an adjudicatory proceeding. So that means if there's an application that's being heard by the commission and it's protested, so you have the applicant and someone who's opposing that application coming in front of the commission and asking the commission to hear the application and to hear both sides, members of the public can make public comment at that adjudicatory hearing. However, there's a limitation on that public comment. The limitation is this: it provides, our current Rule 510A provides that that member of the public has to be sworn in. So they have to take an oath saying that they swear to tell the truth, make their public comment, and then they need to make themselves available for cross-examination by both parties. So most of the time, the parties that appear in front of the commission are represented by lawyers. So a member of the public who wanted to make comment at an adjudicatory hearing would potentially be subject to cross-examination by a lawyer. That has a chilling effect on participation and certainly decreases the amount and frequency with which we may receive public comment in the course of an adjudicatory proceeding. Staff therefore recommends removing that provision from our current Rule 510A, and in our new proposed Rule 512, we don't have any such restriction. Various stakeholders have encouraged us to not delete that provision and to keep that provision in place. Staff doesn't feel that there's any legal requirement that we would actually have to have the process of swearing members of the public in and making sure that they're available for cross-examination. So with that, we have removed that provision from our proposed Rule 512 and don't believe it's necessary to include. Moving on to Rule 523C, that is a current rule that we have, and it governs elements of our enforcement process. So in addition to the general hearings process that the 500 series lays out, the 500 series also incorporates elements of our enforcement process and how that works. So what current Rule 523C provides is that staff can propose that a penalty against an operator be increased when certain circumstances exist. After 181, staff reviewed 181 and felt that it is telling us to go further and to include in our rules as it relates to enforcement to specify that if there are damages to the environment, natural resources, environmental resources, which would include fish, wildlife, damage to ecosystems, that those impacts would trigger staff's ability to increase or request the increase in the penalty that's being assessed on an enforcement matter. So in proposed Rule 525C2, we have included that one of the circumstances when staff can seek a higher penalty is when there has been damage to ecosystems, natural resources, etc. We also are proposing that if there has been threatened or actual harm to a person, that staff be permitted to seek an increased penalty in those circumstances as well. Another element of our enforcement rules that we are seeking reform of is Rule 523E, voluntary disclosure. Staff encourages and appreciates when operators come to them and report voluntarily violations of our rules. These can be everything from paperwork issues, failure to timely file forms, late filed forms, to reclamation issues. It runs the gamut. And voluntary disclosure is important for us, for staff. It shows that the operator is at least being mindful and seeing when they have made a mistake and is coming to us and being honest and wanting to work with staff to get things addressed. Our current rule tries to give a greater incentive for that voluntary disclosure by saying that operators will receive an automatic 35% penalty reduction if they come to us and voluntarily disclose. Staff is recommending that we remove that mandatory 35% penalty reduction. The reasons are twofold. First, we believe staff and the director should have discretion when it comes to penalties. Perhaps a 35% mandatory reduction may not be warranted based upon the facts that staff receives and understands from that operator when they voluntarily disclose. Perhaps the penalty reduction should only be 5%. Maybe it should be more than that. Maybe it should be 40%. But that discretion needs to lie with staff so they can analyze on a case-by-case basis and determine when and to what extent a penalty should be recommended to be reduced by. So staff is asking that the commission remove from Rule 523E, current Rule 523E, that 35%, mandatory 35% penalty reduction. The last rule I'm going to cover today is our current Rule 524. This is the responsible party rule. As Director Murphy noted, this rule has also received quite a bit of comment from stakeholders. And staff feels this is a very important revision that needs to be made in our rules. Under the Act provides that operator may be able to not be liable for a violation of a rule if they're not the responsible party. So if they acquire an oil and gas location and there is found a violation on that location, and the current operator can prove or knows that the prior operator, the operator that they bought that location from, actually was the entity that caused that violation, the Act would allow for the current operator to bring that information to us and to say, we are not liable for this. So when an NOAV is issued, a notice of alleged violation, the director has to have evidence that the director believes the operator that they're issuing that NOAV to is liable for that activity. We have the burden to prove that. If that operator, however, comes to us and says, it actually was not me, it was the operator I bought the location from, or it was 3 operators prior to me who is responsible for this violation, staff will listen to the operator and encourages the operator to bring us information and evidence that would in fact demonstrate that they are not liable. But at the end of the day, it is up to that operator to bring evidence to us to prove that. Again, the director has the burden of proof to prove that the entity that we issue an NOAV against is liable. But if the operator has a defense that it was a prior operator that is actually liable, they need to bring some credible evidence to us to support that defense. So we think that that is a reasonable revision to this rule and is something that would certainly help all parties involved. It would help the director because the director would have information in before it to understand what the history of this location is and to be able to make a determination as to whether or not the operator that we issue the NOAV against is liable. And then also within Rule 526, we proposed to take out some, or to make clear that once an enforcement action is brought before the commission and the commission is making a determination of which operator is liable for the alleged violations, and if there's a responsible party issue involved, the commission, when making that determination, would actually not take into account any contractual or legal disputes between these parties. So if an operator has been issued an NOAV, that operator says, I'm not responsible, it's the prior operator, but there may be a private contract between those 2 operators that say, if there is a spill on this location, the prior operator, the seller, would pay 60% of the cost and the current operator would pay 40%. That's not something that this commission would have to take into account when determining who is liable. So we thought that that was important to specify within the rule as well, that the commission, when making a determination of liability, does not take into account these outside contractual or legal disputes that may exist. And, ultimately, we really want to ensure that this statute, or excuse me, this rule complements the act, and that we believe we've been able to accomplish through some wording revisions within the Rule 526, and also just ensures transparency for the public to understand where an operator is coming as to a defense with respect to an enforcement action. So with that, I'm happy to take any questions that the commissioners may have.
Thank you, Ms. Larson. Excellent presentation. Really helpful to frame the big areas of discussion for us and with our parties this afternoon and Monday. With that, I would ask commissioners to let me know if you'd like to ask Ms. Larson questions.
Mr. Chair, I've got a question, and give me a second as I pull this up. So in 502A, on your slide, it was indicated that in the variances sought from the director, that in that slide, you utilize the term ministerial or procedural, which I think are good words. I'm not seeing those words in at least the copy of the draft rules that I'm looking at right now. Am I missing it?
You are not missing them, Commissioner Mesner. Those words, neither of those words actually do appear in 502A. The way that we've structured the rule is to provide that if the variance is for anything other than a matter that implicates public health, safety, welfare, and the environment, the director would have the authority to grant that variance. And I will allow AAG Minor to refresh my memory. I believe in our SBP for this rule, we've also gone into a little more conversation and discussion about the fact that a Rule 502A variance from the director would apply only to ministerial or procedural matters.
Yes, thank you, if I may, Mr. Chair. That is correct. So I believe this is on page 120 of the Statement of Basis and Purpose, and it does sort of provide that ministerial distinction. I think ministerial is very much a legal term that maybe we overuse as lawyers, but it does refer to what maybe members of the public would think of as paperwork, right? Things that are not especially substantive. And so by using the public health, safety, welfare, and the environment and wildlife resources standard in the rule, that sort of triggers the substance. Those are the substantive areas where the commission has regulations that would need to come to the commission. But we sort of provided a little more gloss on sort of that ministerial versus substantive distinction in the SBP in an effort to provide context for lawyers and other folks in the future who sort of need to understand what falls into which category.
That answers my question. Thank you.
Other questions from commissioners? If not, I've got a couple, or I've got kind of like an area that I'd like to speak to Ms. Larson and Ms. Murphy and Mr. Minor about. The 500 series has been near and dear and severe to my heart for a long time. I was a practicing lawyer before the Colorado Oil and Gas Commission for 2 decades before I found myself here. I found myself, back in 2001 during the infill hearings for La Plata County as the La Plata County attorney. I found that the 500 series sought to provide effective engagement of parties, but I also found as a party that I often did not feel effectively engaged. And in, bringing matters to the commission, I always felt like the sort of procedural barriers were difficult and disallowed folks from being heard. And I know that this is a really important topic for us as we engage in the 500 series. But from a affected person perspective, from a adjustment to local public forum perspective, how does staff feel about the place that you've landed in terms of trying to truly allow for parties to be involved and to allow for parties that are not oil and gas operators to be fully involved? Just kind of like on the scale of 1 to 10, or do you feel good about where you've landed and how you've done? And I know there's been a ton of time and effort on staff's part to think through these issues, and I really appreciate what's before us. But I just wanted to kind of ask that sort of open-ended question, because this is really important to me. And being chair of the commission now and ensuring that we're delivering on this point is really important. And I know we're going to hear from all the parties about it, but I just wanted to give staff a chance to sort of weigh in. Director Murphy, Ms. Larson, Mr. Minor.
Thank you. Thank you, Chair. I think that where I would start is that, yes, the point of looking at the definition of affected party is to address so many of the concerns that you've articulated. And I'd actually love to have Mimi walk through her discussion on that one more time, because I do think it's really impactful and important. And she is the one who led the charge in terms of identifying the issue and the solution and working it through over the course of the last few months to help us understand where staff has landed as a recommendation.
Certainly, I'd be happy to. So when we look at affected person, that new concept that we're bringing into the 500 series, staff recognize that there were procedural barriers to full participation in various applications that would be heard by the commission. And those barriers, just from what I could observe, were just an outgrowth of how oil and gas operations has historically been completed and done. And our rules hadn't necessarily kept up with the progress and how things have changed. So recognizing that, when we look at the definition of affected person, it's quite inclusive. We want to ensure that anyone who feels that they in fact have an interest that needs to be heard by this commission will have the opportunity to come before the commission and make that request. We have not put in barriers that you have to be a mineral owner here or be some type of person that would only be able to participate. Again, just walking through the 3 elements that we will need to see in a request from someone is you do have to have some interest, and you have to be able to explain what that interest is. And the interest can't be held in common by everyone. So it really is a broadening of the type and number of persons who are going to be able to participate in our hearings. And again, looking at it from the perspective of our new unified permitting process, we recognize that through the OGDP process that the commission will be hearing these OGDPs, and the commission will want to hear from impacted persons, affected persons. And so we want to ensure that there is a process for them to come before the commission and to be heard. And I would just tag on as a footnote, our revisions to Rule 510, now Rule 512, proposed Rule 512, decreasing the barriers to public comment in the course of an adjudicatory proceeding is also another element of that. So if you are you feel you have a great interest in an OGDP, perhaps your interest though is a common interest, we still want to hear from you. And the revised Rule 512 ensures that you can come before us in an adjudicatory proceeding and have that comment heard.
Thank you. Thank you for that recap. Commissioner McGowan.
Thank you, Mr. Chair. I'm wondering if one of you could maybe provide a quick distinction between what we've put into the rule and the definition in APA, because several stakeholders refer to the APA definition of an affected person. Maybe it would be helpful for us to have some background on that.
Certainly. So within the APA discusses affected and aggrieved. And in our rule proposal, we define an affected person to mean any person who satisfies the requirement of Rule 507A. And Rule 507A discusses that an affected person is someone who is adversely affected or aggrieved. So we were building in the elements from the APA into our Rule 507 to ensure that we capture those elements of the APA definition. It's important, we feel, to have that APA definition incorporated into our rules, because then we also are opening up case law, body of established law that has dealt with this question of who is an affected person, what does that mean, what elements need to go into proving that you're an affected person and should be included in an adjudicatory proceeding.
Ms. Larson, can you explain that, just dive a little deeper into that point about how the definition, if used as the APA definition, is allows for us to dig into that case law? What does that do? What does that give us? And I can also look to Attorney General Minor for this, but for the non-lawyer, I want to make sure everybody understands the significance of that. And I'm sorry, Commissioner McGowan, I didn't give you a chance to follow up.
Sure, I can take a crack at answering that, and AAG Minor, please jump in. But a core element of legal proceedings frequently is something we call standing. Standing is just a fancy legal word for, should you be involved in a case? Do you have the right to have your voice heard in a case? So an administrative agency, which the COGCC is, we are subject to our act, the Colorado Oil and Gas Conservation Act. We're also subject to the Colorado's Administrative Procedure Act. And the Administrative Procedure Act will govern how agencies operate. It sets out by statute sort of the operating procedures for what needs to happen, when and where and why. So within that APA, there is a definition of affected person, meaning if you are someone if you're someone and you believe that you have been impacted by an action that's taken by an agency, this is the definition of what that means, of who you are as an affected person. So there has been a lot of litigation over the years as to what an affected person means, what elements you have to demonstrate in order to qualify as an affected person, what limitations there are on an agency, what rights an affected person has when dealing with that agency. There's a lot of law out there that talks to this issue. And by incorporating the definition of affected person that exists in the APA into our rules, we are then able to look to that case law as guidance, as to give us a roadmap as to how we need to address affected persons in our rules and in our operations. Attorney General Minor, Assistant Attorney General Minor, did I screw that up totally?
No, I mean, as always, I think you explained it far better than I could. I think maybe the only thing I would add is that, as Ms. Larson was saying, one of the main benefits of tying our standards for affected person status more closely to the APA is that there really is that body of case law to build on. So the hearing officers and administrative law judges within the commission, as well as the commissioners, you yourselves, can be informed by along many decades of judges looking at really who should be involved in a court proceeding and how interests are determined, which I think can be helpful in you instead of having to try to recreate some of those standards from scratch. It's helpful for the parties involved because they can also look to that. in the statement of basis and purpose, we describe some examples of areas where courts have recognized sort of affected person status or interested person status, which might be, for example, someone with recreational interests. So someone who recreates very frequently, say they have a mountain bike trail that they go on every day after work, and they would have an interest in what's going on in that area. So I think that that's just one example where it allows our rules to provide additional clarity to parties and especially their lawyers, as well as the people who have to make these decisions, the hearing officers, administrative law judges, and commissioners, without having to go through on a case-by-case basis and spell out in our rules every category of injuries that might fall within the subset that lead to affected person status.
Other commissioners with questions? Commissioner Messner.
Thank you, Mr. Chair. That was a good explanation. That was helpful for me. I did have some questions around 526 and the responsible parties. And just generally speaking, how does this section interact with the sections in other series around transfer of ownership or responsibility for an applicant over their subcontractors or those pieces? I wonder if you could just talk a little bit about that.
Certainly. Thank you for that question, Commissioner Messner. So, for instance, in Rule 218, we've proposing to establish a new presumption of liability for remediation. And that presumption of liability is that remediation would rest with the operator that is the successor in interest, meaning the buyer, the current operator of a location. So that is, an important rule that I think certainly does correspond and correlate with this Rule 526.
Mr. Chair, Ms. Larson, if I could add
Please.
to that.
Yes.
I think that in some ways the purpose of getting clarity on that status in Rule 218 is to avoid some really complicated situations that could arise later under Rule 526. I think in the technical staff's experience, often the remediation issues that really led to difficult questions in terms of responsible party did sometimes involve transfers of operatorship where there wasn't as much clarity for staff as to who was responsible for what. And so you can think of maybe Rule 218 in some ways as an avoidance rule. The idea is, let's get this figured out at the time that a transfer occurs rather than having to end up in a hearing where Rule 526 comes up and we are having to figure out that responsible party later on.
Thank you for that clarification.
Can I just follow up just a little bit? So, and because I think some folks who aren't lawyers have questions about some of, how this actually works in application. And so my understanding is that once we've made a clarification in the rules that says that, an operator is responsible for all of their subs. And that to me was clear. There's no question about that. So there's no way that an operator could say that they're not a responsible party. The responsible party is my subcontractor. And so I'm going to, place the blame on them under Rule 526. Is that correct?
So I think an important distinction here is to look at this responsible party issue comes up really with historical violations, meaning I'll just give an example, you have a location and a spill has been discovered on that location. That current operator may say, it's not me, it wasn't my subcontractor who did it. The spill is 15 years old. I acquired this property 6 months ago. It couldn't be me, I'm not responsible, I'm not touching it, not cleaning it up, done. So there have been circumstances, rare, but nonetheless circumstances where an operator has said that and has sought to devoid itself of any and all liability. The responsible party provisions here put the onus back on that operator to say, okay, please bring us credible evidence that that is the case, that you in fact have no responsibility whatsoever for that historic spill. I think the circumstance that you're addressing is if there is an active spill, the operator, active spill on the property, on that location, the operator says, well, I sent my subcontractor out there to do whatever maintenance was necessary. They failed to do that maintenance. That is why there's this active spill. I'm not responsible. You're correct, Commissioner Mesner, that we have sought in the rules to clarify that the operator is responsible for the actions of its subcontractor. And that has been staff's position historically when issuing enforcement actions, that we would hold the operator responsible for the actions that have occurred on its location, even if operator said, well, it was my subcontractor. So just, I think that slightly nuanced little differences there.
Thank you for that, Ms. Larson. Commissioner Gonzalez.
Yeah, so I appreciate the explanation. I want to get this clear. So basically, it's a presumption that the liability runs with the property until the current operator brings additional evidence that says, hey, it wasn't me, or happened before I got here, and here's the evidence of that. I want to make sure I got that right. I see AAG Minor kind of shaking his head. So jump in and clear me up, and then I'll follow up my next part of the question.
Certainly, Ms. Larson could do it. Perhaps my facial expression was just more of a giveaway there. So this is really an issue in Rule 218, which of course we'll be talking about next week or 2 weeks from now. But that does say that when something is being transferred, a permit, a location, a pit, whatever that thing that is being transferred is, the general presumption is that the new operator will be responsible for that transferred asset or liability. However, the point of the Form 9, which is created in Rule 218, is to allow the parties involved in a transfer to tell the commission staff for every item that is being transferred who is responsible. So, so that default presumption does exist. However, that is the point of the Form 9, is that the parties can tell the commission who's responsible for what in the future. So while that default is built in, there are many ways to sort of have the default not apply. Ms. Larson, anything to add there?
No, I think you covered it. Thank you.
Yeah, so then when there's a determination or I guess the director of the commission, has their evidence that there should be an additional responsible party, that party's been identified, how is that party held liable for actions that they're no longer the operator for? I'm curious what the consequences look like and how you maintain that enforcement for potentially stale is not the right word because the problems will be current, but some sort of staleness in the transfer of responsibility for whatever the issue is at hand. Am I making sense of that question?
Attorney General Minor or Ms. Larson?
So I can start. I'm happy to start. So to your point, Commissioner, we have heard in the past from operators that if they allege that it was a prior operator who's responsible for the violation that we have alleged that current operator to be liable for, and they say, no, I'm not responsible, you need to go after that prior operator. At times there are limitations as to whether or not we're able to go after that prior operator, mostly because that prior operator may no longer be an operator in good standing in Colorado. They may have left or no longer be in business. So that certainly is a limitation. And we do recognize in the revised Rule 526 that if there is essentially a dispute as to who the responsible party is, that the commission can make a determination as to the degree of responsibility, right? And to what extent potentially the seller was liable and perhaps the new current operator is liable. So we do take that into account. But again, if that prior operator is no longer an operator in good standing in Colorado, we are in a very difficult position because there's no one to go after.
And Ms. Larson, I will add to that I think that is the reason that the responsible party provisions of the Act are part of the orphan well section of the Act, right? So I might just read 2 sentences to you from 3460-124 subpart 7, which explains that if the Commission determines that mitigation of a significant adverse environmental impact on any air, water, soil, or biological resource is necessary as a result of the conduct of oil and gas operations, the Commission shall issue an order requiring the responsible party to perform such mitigation. If the responsible party cannot be identified or refuses to comply with such order, the Commission shall authorize the necessary expenditures from the fund, meaning the orphan well fund. So this certainly wouldn't occur in every case that I think would sort of match the situation that you asked about, but one thing that might happen is that if there is some sort of historic remediation issue that is discovered where the operator just simply no longer exists, that might be one category of remediation that ends up going into the orphan well category.
Commissioner McGowan. And Commissioner Nanjapa, I think I may have missed you. Ms. McGowan, we cannot
Want to
hear you.
go, Commissioner Nanjapa first?
You can go ahead especially if it's along this line.
So related to this, and now I need to think of this in this series. Hopefully, we're cutting down on the problem of responsible party, because when there's a transfer of assets now, before the Commission signs off on the transfer of assets, all of that is supposed to be worked out. Who owns what and is responsible for what before the transfer of assets, before we'll sign off on it as a Commission.
You mean under the proposed?
Under the proposed rules, right? And so kind of like when you buy a house, you have an inspector hopefully come and look at it and tell you where all the liabilities are, and you work it out with the current owner before you buy the house, and you say, well, you got to fix this first, you got to take care of this first. And then after that, I'm mostly responsible for what happens in the house. And so I think that we're hopefully would not have too many instances of that anyway, because of the new proposed rules about transferring assets and being very clear when you transfer those assets, who's responsible for what, and signing off on all of that. I think, if I'm understanding correctly.
Yeah, certainly. And again, we can delve into this issue in greater detail when we get to the 200 series, but that certainly is staff's proposal as it relates to 218, to be able to address up front these issues, so down the road we're not left with the circumstances where we're trying to determine who in fact the responsible party is.
And I will once again, if I may, sorry, I will also add, Commissioner McGowan, when we get to your favorite series, the 900 series, staff have proposed several rules that are designed to provide clearer timeframes and more reporting around existing remediation projects and the status of their cleanup. That I think will also help making sure that remediation happens in perhaps a somewhat more timely fashion and is kept track of more clearly by staff, that can also relieve some of those questions around what sort of remediation projects exist at the time that an asset is transferred.
An important thing I think that I want to add to Commissioner McGowan's comment, just for clarification, is that while the transfer of operatorship new rules are going to help prevent a lot of this kind of who the responsible party is in the future for acts that occur after that transfer has come into place, or after these rules have come into place. Over the last decade, there's been tens of thousands of acres that have been transferred where we don't have those same tight rules to govern. And the issues that we may be having before us as a commission now are likely to have occurred prior to the new rules of transfer of operatorship, which is why kind of this responsible party rule is important to be viewed, not just in the context of that transfer of operatorship, but also in the context of a standalone, how we determine that responsible party.
Commissioner McGowan, do you want to follow up on this? We're getting to you, Commissioner Nanjapa.
I will just go after Commissioner Nanjapa. I have another question about affected person, so I'll go after Commissioner Nanjapa.
No, please, Commissioner McGowan, go ahead because mine's a different question.
Going back to affected person, are some people automatically going to be affected people because of the way we set up the rules? And so, for example, I think there was a comment from one stakeholder. Are you automatically, let's say we pick a setback amount of 2,000 feet for X activity, and that person lives within those 2,000 feet, or there's priority habitat within those 2,000 feet. Is there automatic standing then for the person who's living within 2,000 feet, or I don't know if priority habitat can have standing, but someone who represents the high priority habitat would automatically be an affected person?
So the way the rule is currently structured is an affected person, you may automatically be an affected person if you're a governmental entity. So that would include state agencies, relevant local governments, governmental agencies, entities are automatically affected persons. If you're not a governmental entity, agency, you would need to petition in formally, and you would need to describe each of those three elements that I discussed. You know, what is your interest? How's that interest affected? And is that interest held in common?
Any follow-up, Commissioner McGowan? Commissioner Nanjapa.
I just want to make sure. I thought I saw Director Murphy maybe raising your hand. Okay, I just want to make sure. Okay, I'm going to go kind of to a very basic question, and this was something I meant to ask of staff previously, and I had neglected to do it. I was just trying to look through and see if I could find it myself, but I couldn't. So apologize in advance for this very basic question, but where do the variances come into the process? So when an application has been put in for an OGDP with the Form 2A, et cetera, is that when a variance can be requested? Is it after the permit has been approved? And thank you for my, for humoring this ignorant question.
It's not an ignorant question at all. So we specify in our rules what type of applications can be filed and brought in front of the commission. So a variance can come in almost at any process, meaning if you have an OGDP and as part of that OGDP, an operator says, I don't think I should have to conduct an alternative location analysis, say, for instance, that would at least be a variance from our rule, and that would be something that they would have to include in their hearing application. You may have an operator of an existing location who elects or is seeking the commission to relieve that operator of a certain reclamation requirement. So the location's been in effect, in existence for a number of years, and that operator would then file an application under our Rule 503, and it would be under Rule 503 G9, that the operator in this example would file an application with the hearings unit, which would then be presented to you, the commission, saying, I don't think I should have to conduct the reclamation according to the rules, or here's the way in which I want to conduct reclamation. It's a little different. Please allow me to do that. Grant me this variance. So it really can come in at any stage of an oil and gas operations, permitting up to you're ready to close out a location.
Commissioner Nanjapa.
Okay, yeah, great. No, that's very helpful. I appreciate that. And it makes sense, especially given that it can happen along the way. So then I have a more specific question on 502C. And in particular, the subpart 3 there. So is that basically suggesting that if there were reasons that a permit might, or an OGDP may not otherwise be approved because of, other aspects of our regulations. But there was a proposal to include other, beneficial actions or mitigation measures. So for example, as we were talking about in some of the prior rules, if they were to remove old pipelines or, cap and plug or reduce emissions or et cetera, would that be an appropriate condition to request a variance, or would that be more part of the initial, more general application process and discussion?
So I think the answer to your question is yes for both. Certainly, if an applicant operator sought to be relieved of a certain requirement under our 300 series and said, I shouldn't have to comply with this element of your 300 series rules, but what I'm going to do is do this beneficial thing in place of it, that would be something that operator would bring forth in its application to staff, and it would also come forward in the hearing application itself as well. So when the commissioners actually got the full administrative record before it, which would include the Form 2A, potentially more than one 2A, all the plans that go with that 2A, potentially a drilling and spacing unit application, you would see that request, and you would see that that has been noted in the application that came into staff, and that, to your point, it should also be noted in the actual hearing application that it is made to the hearings unit. Another instance where this may come into play, it's my favorite example of the day, but in a reclamation sense, if operator says I shouldn't have to reclaim these lands based upon these requirements in this manner, but I'm going to do something else that's beneficial. It's not covered in your rules, but I think that this is actually a good thing for the environment and for the ecosystem. Please consider it. So again, I don't think I should have to do this, but what I am going to do is as good or better than what you would require.
Okay.
Commissioner Nanjapa.
Thank you very much. And I had one more question, if I may, Mr. Chair.
Please.
So I noted that there aren't, at least as far as I could tell, any specific hard lines about what we wouldn't accept. Is that sort of intentional so that we can consider case by case, the particulars of a variance request?
So yes, in that we do not specify or put a limit on what requests may come in to the commission. Ultimately, it's a request for a variance to any rule, order, or regulation that we have. So an applicant would bring forth its request, and then it would be up to the commission to determine whether or not that request was valid and should be granted.
Okay, and then last, related to this, is just, was there any thought process, I mean, that maybe sort of answers this already, but with respect to DI communities and variances, and whether or not there would be an exception there. And I would also, look at that with respect to certain other pieces of our protections, like priority habitat, for example.
Certainly, we don't, again, spell out within the 500 series or specify a variance would need to take into account a disproportionately impacted community, wildlife habitat, etc. However, if an applicant is coming forward and the request for the variance specifically would impact that disproportionately impacted community, wildlife habitat, etc., staff is going to be reviewing that and then making a recommendation. I will also note too that a variance application would be open to the petition affected person process, as would any application. So if we have a variance request come in, it is noticed to the public, it's going to be heard. A member, if they happen to be part of a disproportionately impacted community that they feel would be impacted by this variance request, we would certainly expect that they would seek to petition in and to have their concerns heard. So through staff and then also through the public notice process, we feel that there are opportunities for all sides of an issue and a request to be heard and all evidence to be brought before the commission for full consideration.
Mr. Chair, if I may quickly add to that, I think one meta point that goes with what Ms. Larson said is that the commission's current rules sort of as a hodgepodge spell out in different places that a variance is allowed. And so you'll see, unless a variance is granted, sort of in a lot of different places, and staff tried very hard to sort of streamline that and just have one variance rule instead of specifying in a whole bunch of different places when the variance is allowed and under what circumstances, which I think really improves clarity overall. It removes questions about, is a variance allowed for a rule that doesn't say it's allowed? And so really the only place I think now in the 200 through 600 rules where there's sort of a special provision for a variance right now is in Rule 411, which involves public water systems. And there are sort of historic reasons for that and involves CDPHE consultation. But other than that, sort of all variance related provisions are now found in Rule 502.
Thank you,
Thank you very much.
Attorney General Minor. Commissioner Messner, you've been holding your hand up patiently.
And I'm just trying to get clarity on this particular topic too, because I've heard a little bit that we can request variances for anything, and I acknowledge that, but in 502C1, it clearly states that the operator will, or the applicant will have had to have made a good faith effort to comply or is unable to comply with the specific requirements that they're seeking a variance from. And so, you know, a rule to get a variance or a reason to get a variance would not be, I don't feel like doing that. There's got to be, you know, a very specific reason or an attempt to make that would initiate, a showing has to be made to initiate that. So I certainly don't want it to be thought that, you know, an applicant could just ask for a variance just because. I feel like I'm right there. Am I correct in that interpretation?
Yes, you are indeed. Thank you. An excellent point. Certainly for a variance to be granted, that applicant has to comply with our rules. And as you point out, C1 makes it quite clear that you can't just say, I don't feel like doing it, so please give me a variance. You have to demonstrate that you've made the effort to do so, or it's impossible to comply. You're incapable of being able to comply. So there are elements that must be met in order for the commission to grant that variance.
Do we have other commissioner questions for staff at this time? Seeing none, I will have the record reflect that we are 3 minutes ahead of time on our schedule after a week's worth of rulemaking. That's historic. We'll take a break until 3:10, and then we'll come back for initiation of party presentation. All right, looks like we have our commissioners present, and looks like we have our panelists also present. Industry folks, do you have all your panelists that you are desiring? Is that a thumbs up, Mr. Neslin? Thank you. All right, Ms. Larson, set the stage. We have the industry panel group going first, and they have how many minutes?
They have 20 minutes.
20 minutes. All right. So I will look for whomever's going to lead to unmute themselves. Voila, there's Mr. Neslin doing that. Take it away.
Thank you. Thank you, Chairman Robbins. You can hear me all right?
I can.
Okay, very good. This is Dave Neslin speaking on behalf of the industry group. Today, we're presenting a panel on 3 important 500 series issues. The largest operators in Colorado will explain the use and importance of variances, as well as changes needed to the draft rules regarding local public hearings and voluntary disclosure. You'll hear from Rob Mathis of Occidental and Greg Nybert of Noble Energy. Additionally, Vanessa Chase of PDC is available by phone to answer questions. Rob, please go ahead.
Thanks, Dave. Once again, this is Rob Mathis, and I'm Managing Counsel for Occidental, overseeing the legal operations for Oxy here in the Rocky Mountains. And today I'll be testifying regarding 2 specific rules in the 500 series, 502 variances and 511 local public hearings. I want to note the Commission to note that Oxy generally supports 502 as set forth in the August 17th version, with some minor revisions that will be addressed in more detail by my colleague, Mr. Nybert. Hypotheticals aside, I would first like to address what is, I believe, a common misperception regarding industry's use of variances. Unfortunately, I believe many members of the public believe variances are routinely requested by operators and granted by the Commission staff in order to escape or skirt the Commission rules. This has not been my experience and is not how Oxy utilizes variances. Rather, Oxy uses variances sparingly and usually for specific circumstances. Over the past 2 years, Oxy subsidiaries have filed less than 80 requests for variances related to final reclamation requirements, and all were filed at the surface owner's request and with a signed waiver from the surface owner. Let me just say that again. All were filed at the owner's request. The 4 most common requests we receive are, in order, to leave a road in place, 2, to leave a cattle guard in place, 3, to leave a pad level for minor construction by the surface owner or an equipment storage yard, and 4, occasionally leave lands graded to a specific level for future development. Because these requests entail less than complete reclamation required by the current 1200 series, a variance is required. It's important to note that in all cases, these areas are still protected against normal stormwater and other protective measures. It's also fundamentally untrue that all variances are granted by the Commission using a rubber stamp. These requests are carefully reviewed by the Commission's expert staff using an on-site vision, and the imposition of conditions of approval is necessary. It's also important to note that not every request is approved. Additionally, over the past 2 years, in the past several months, because of the dramatic and wholly unexpected downturn in the economy caused by the pandemic, Oxy has made less than 20 requests to delay interim reclamation standards. These are primarily for pads where operations were commenced and planned before Oxy halted its drilling and completion operations in the DJ in March and April. Oxy has plans to return to these locations to conduct additional operations. Again, each of these requests is made only with the surface owner's approval and a signed waiver. The elimination of variances or significantly increasing the time necessary for a variance approval would damage the relationship between operators and surface owners and potentially infringe upon surface owners' rights. Colorado law requires operators to reasonably accommodate surface owners by minimizing intrusion upon and damage to the surface or land. That's Colorado Revised Statute 34-60-127(1)(a). A component of reasonable accommodation is obliging surface owner requests when it is safe to do so, particularly at the final reclamation stage. Outside of reclamation-related variance requests, Occidental rarely submits variance requests pertaining to specific technical needs. I addressed one such request from several years ago in my written testimony that had profound environmental benefits, and I'm happy to discuss that more during the question period. Eliminating the ability of operators to obtain variances could result in unnecessary expenditures or operational difficulties when, for practical reasons, the director could waive certain requirements without compromising public health and safety, welfare, the environment, or wildlife. With that, I'm going to share my screen and talk about Rule 511. Hope you can see my screen now. Rule 511 would allow any person to request a local public hearing. This is a significant departure from the COGC's March 15, 2020 11 draft that allowed a relevant local government, proximate local government, or a tribal authority to request such a meeting. Allowing any person to request a local public hearing is overbroad and could strain the commission's time and resources and could also complicate local permitting. Allowing any person to participate, regardless of whether that individual meets the standing requirement set forth in Draft Rule 507A, could significantly slow down the oil and gas development plan process by entertaining claims of individuals that do not live anywhere close to a proposed development and requiring the holding of multiple public hearings over a single OGDP. Occidental requests that the Commission revert back to its March 15, 2020 Draft 511A with one change. It's set forth here. If the relevant local government does not regulate the siting of oil and gas locations, a proximate local government or tribal authority may request that the Commission hold a hearing. Even with requests to change, the public would still have a chance to participate in the process. Draft Rule 303D provides for public review and consultation of an oil and gas development plan by providing a general public comment period and notice and comment and the opportunity to participate to specified parties as set forth in Draft Rule 303D. These individuals would also receive notice of any final director decision under Rule Draft 306D, providing their participation is guaranteed. With that, I'm going to turn the testimony over to my colleague, Greg Nybert.
Good afternoon, Commissioners. My name is Greg Nybert, Senior Attorney at Noble Energy here in Denver, where I manage Noble's legal approach to regulatory compliance and enforcement matters. I'm testifying today concerning director approval of variances in Rule 502 and the penalty reduction for self-disclosed violations in Rule 525. Taking variances first, Noble generally supports Draft Rule 502 with one caveat: to allow the director to continue to approve common, environmentally benign variances. Variances are an important tool for both the operator and the Commission. No rule, regardless of the careful considerations in drafting and implementation, can anticipate every circumstance that may arise. Variances allow for an operator to be nimble in the face of sudden, unanticipated events such as COVID and resulting commodity price decline. They respond to surface owner, community, and even personnel concerns, and they allow the COGCC to address these matters effectively and in a manner that also protects public health, the environment, and wildlife. Noble operates around 4,600 wells across 1,600 well pads and 1,500 production facilities in Colorado. And within the last 2 years, Noble has submitted a little over 50 variance requests to the director. Like Oxy, Noble's variances generally concern final reclamation requirements following well abandonment and are always done at the direction of the landowner. This appears to remain consistent across industry as a whole. In reviewing the approved variances reported to the Commission in its staff reports from March 2015 to April 2020, a little over 61% were for final reclamation. A number of the other approvals included similarly benign matters such as hearing notices, transport of drill cuttings, and signage. A community coalition claimed that reclamation variances only account for 30% of the total over a similar period. This is simply incorrect. Where an operator may submit variances on multiple wells, the group consolidated each into a single variance request, significantly underestimating the total number. Variances are site-specific, and each well requires an independent variance request. If you include each variance in your evaluation, you will come up with a majority of the approvals being reclamation variances, as I did. These variance requests typically do not result in adverse impacts and should be reviewed and resolved administratively by the director with staff support. Let me pull up my screen. According to the Statement of Basis and Purpose, proposed Rule 502A limits the director's ability to consider variances to ministerial or procedural requests. Depending on how this language is interpreted and applied, it could restrict the director's ability to grant variances for reclamation and similarly benign matters. Variance requests, especially those concerning reclamation, involve conflict between Commission rules and the landowner's desires for the future use of their property. It is imperative to find quick resolution to these issues to avoid soured landowner relationships and litigation risk. In the vast majority of cases, the director could, with staff consultation, quickly approve these variances without compromising public health, the environment, or wildlife. For the commission to consider the variance on a same matter would require the same staff evaluation. And additionally, as Mimi said, an application under Rule 503, but also a 60-day notice requirement under 504A1 and the petition process under Rule 507. This only acts to delay the consideration of a variance, especially when a reclamation variance does not result in adverse impacts. As shown here, Noble requests the statement of basis and purpose for Rule 502A be revised to permit the director to consider variance requests for reclamation. Turning now to violation self-disclosures under Rule 525E, the commission should reconsider keeping the minimum 35% penalty reduction for voluntarily disclosed violations. Over the last decade, various federal agencies have made a concerted effort to incentivize self-reporting, typically in the form of reduced monetary penalties for voluntarily disclosed violations. The current EPA audit policy provides similar protections and substantial penalty reductions of up to 100% of the assessed penalty, depending on how the violation was detected and disclosed. CDPHE also may waive violations of state environmental laws if they are voluntarily disclosed under its audit policy. In fact, I'm not aware of any federal or state agency that has reduced the incentives for self-disclosing potential violations. This 35% penalty reduction is a significant incentive for operators to self-disclose and to quickly address violations, and in turn assist the commission in satisfying the goal of protecting public health, the environment, and wildlife. Thank you, commissioners. Rob and I would now be happy to address any questions you may have.
Is that the conclusion of your testimony, Mr. Neslin?
Yes, that concludes our testimony, commissioners.
Okay. Commissioners, we now have opportunities for questions. I may go first. To either of you, the idea of, or your concern around less director oriented variance and making it go to commissioners, I guess a couple of points. One is there still is this ministerial issue that the director can do. And I guess number two, are you kind of forgetting we've got a professional commission that's going to meet once a week, and you will have access to professional commission to be able to act upon variance requests in a much greater capacity than in previous iterations? Maybe I'd like some thought or comment about that.
I think I can take a stab at that, Mr. Chair. Thank you. Regarding the ministerial nature, I think the statement of basis and purpose, it really, as I said, is how it's applied. And as I noted, over the past 5 years, there's been 61% of the total variances approved by the commission have been reclamation. And in most cases, reclamation does not really adversely affect public health, safety, welfare, or the environment. If there is, the director can put conditions of approval on those. And additionally, we're coming in to the process with a landowner waiver 100% of the time. We're not doing this to circumvent the landowner. We're coming with the landowner approval. And it's that fact that the director could administratively approve these matters. To your point about the professional commission, I take that point. However, we're still subject to the 60-day notice requirement under 507A and the petition requirement, the petition requirement under 507 and the notice requirement under 504. So that adds 60 days to the process, no matter how long it takes on the front end for the commission staff to review the variance request.
But aren't these majority of variance requests that are landowner reclamation sorts of things? I mean, it doesn't seem like that would be something that is expeditiously needed. I mean, if it's 60 days out. I mean, it seems like when you're planning reclamation, you know, that is thought out in advance. And if you know you're going to need something, that you could, you know, get the approval, get it to us, we take a look at it, we say yeah, and then you're moving on.
And I think that regardless of the type of variance that we're submitting, even for reclamation, we are seeing considerable time for staff evaluation and consideration. And
But
if
the
we
staff
can't move,
I'm sorry, I'll let you
Oh.
finish.
and if we can't move to hearing until 60 days after notice is posted, then we're just adding the 2-month time frame on the back end. That's my concern.
But there would be
Now-
a staff evaluation, even if it were to be a director variance decision. So that time is already built into the clock either way, right?
I don't necessarily think so, because the director could take action on the variance the day after the staff review occurs. If the staff review occurs and we have to wait 60 days for a hearing, and then subject to your hearing schedule, understanding that you meet weekly, again, puts questions of timing in my mind.
All right, thank you. Other commissioners with questions?
Mr. Chair, I've got a couple.
Okay, and then I'll acknowledge Ms. McGowan and then Ms. Nanjapa. So Commissioner Gonzalez.
Sure. So I appreciate the suggested language or kind of the way you've captured it of allowing the director to continue to approve common environmentally benign variance requests. As the rule's currently written, it basically allows the director to approve variance requests that do not implicate public health, safety, welfare, the environment, or wildlife resources. What's the difference between environmentally benign and something that doesn't implicate public health, safety, welfare, the environment, or wildlife resources?
Yeah, Commissioner Gonzalez, I don't know that there's a change. You got to remember that our pre-hearing statements were submitted prior to the most recent change on August 17th, where the changes were made. And so I think we agree with the current standard as set forth in the rule about so long as it does not impact public health, safety, or environment. The nuance explained today by Ms. Larson and AAG Minor was a little bit different than we understood, limiting it to only ministerial acts. Although we saw that language in the statement of basis and purpose when it came out in this most recent version, we still thought, or I still thought, the director had the discretion, so long as the environment was not impacted, that a variance could be granted.
Okay.
Commissioner Gonzalez.
And I appreciate that. I think there's some clarity in the statement of basis and purpose that may need some alignment with the rule language. But I wanted to make sure that the rule as written itself seems to be aligned with what Mr. Nybert suggested a few minutes ago. I guess this is for you, Mr. Mathis. I think you made the comment about local public hearings complicating local government permitting. And I'm curious if you could tell me more about what that means and what you're thinking in that regard.
Sure, I guess my thinking there is that where a local public government, such as Weld County, already has a very detailed process to consider applications, they have their own hearing system, their own mechanism of notifying their public. If we layer on top of that a commission one, there could be a source for confusion about which one am I supposed to go to? Am I supposed to go to both? It just seems like it could be considered by some of the local governments as an intrusion into their system rather than an overlay over that system.
I mean, is there a way to look at it complementary, right? You know, we're talking about the local governments having their process, COGCC having their process in terms of, you know, where the local government may not be as protective as we are obligated to do under our mission.
It could be. Yep. It just seems like there's a lot of uncertainty regarding that process since we're all going into a bold new world.
Sure. The last question I have, I think it will be the last question. So under the kind of the penalty reduction, right? There's that shall penalty reduction that's being removed that is obviously some concern at issue today. And I'm curious, you know, this is kind of going to be a general question, but you know, why is there an incentive to self-disclose? Isn't self-disclosing just the right thing to do? And why you need an incentive to do the right thing?
I think disclosing is the right thing to do, and I think operators will continue to self-disclose. I think what the 35% penalty reduction as enumerated in the current rule and what we're requesting to remain does is that it puts the commission and the operator who does self-disclose at in a position to work the violation cooperatively and find quick resolution to the violation, rather than a situation where a violation is discovered and puts us at an adjudicatory hearing through the enforcement process.
I think that's all my questions for the moment. Thank you, Mr. Chair.
I think it was Commissioner McGowan next.
Commissioner Gonzalez covered my question. Thank you.
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you all for your testimony. I also, one of my questions got covered there from Commissioner Gonzalez. I did want to ask Mr. Mathis, I think you mentioned some of the examples of what you do in final reclamation, and I missed a few of those. I was wondering if you could reiterate. And also you mentioned one particular instance that had profound environmental benefits. I'd be interested in hearing about that. Excuse me, but I also wanted to know what other examples of variances might typically be that are outside of reclamation.
Of course, Commissioner. The four most common that we seek in the reclamation are leaving the road for the landowner, 2, leaving cattle guards in place, or road gates as they're technically called, for the landowner's use. Occasionally leaving a pad for the landowner to use as a future storage site. So for example, they may want to park their tractors there, and so they'll want that small leveled area left, or a smaller leveled area left. And then finally, occasionally, where a developer has future plans, they may make specific requirements for us to grade to a specific level so that they can go forward with their future development in the area. So those are the four common that I brought. The example that we have sought a variance for, and this was several years ago now, but we sought a variance to move towards our tankless system that we have throughout the DJ Basin, where we don't have oil tanks on any of our facilities, and instead the oil for the most part is transported to what we call the COSIF, or the Central Oil Stabilization Facility. So the variance that we sought there was a variance from current rule through 328A and 329, which is measurement of oil and measurement of gas. Under the those current rules, you have to measure on lease, which of course makes sense when the rules were drafted, because we were in a very vertical world where the measurement would take place on location, and that's where you'd know it was done. For environmental reasons, we decided if we built a central facility where we would take what we call bubbly gas that still has some oil that still has some natural gas entrained in it, to a central facility for further processing there, we could impose far greater environmental controls from an air quality standpoint, because with kind of that mass, you could do more than you could ever do on individual locations. So we worked with the commission staff, we worked with the Bureau of Land Management, and we also worked with the Colorado Association of Mineral Owners, or CAMRO, to ensure that they were all comfortable with the way we were going to measure. And then we take what's called the high pressure gas, or the HPV, to that central facility where we're able to process it again with far, far less air quality restrictions or emissions than you could ever have on an individual pad. So it's something, quite frankly, that Occidental is quite proud of in our DJ Basin assets. And that's the lawyer's explanation. I should caution you, not the technical staff's.
Commissioner Nanjapa, follow up?
No, thank you very much. Appreciate it.
Commissioner Messner.
Thank you, Mr. Chair, and thank you for the testimony. I had a couple of follow-ups to Commissioner Gonzalez's questions, and thank you for asking all of my questions, Commissioner. Those were good questions. But on the point of the public hearing piece and the local governments, I think it's important to understand that, at least the way that I'm reading the draft rules, that there is discretion that is given to the commission whether to decide to hold that public hearing or not. And if there was a situation where there was a local public hearing by a local government, particularly in a situation where that local government may ask for a joint public hearing that included the COGCC, that may be an opportunity for us to actually complement that local government's public hearing and not require duplication or multiple public hearings and add to that confusion. So I think it's important, at least as I'm looking at that may be how this applies on the ground. And so number one, I'd be curious on your thoughts on that. And then number two, when we're talking about this reduction for self-reporting, I mean, I guess I'm not sure I necessarily see it as a reduction. It's just taking out an arbitrary percentage and creating some discretion for the commission to determine, you know, how to apply a reduction for self-reporting. I guess I'm envisioning a situation where if an operator in their best management practices is consistently evaluating their operations to ensure that they don't have any environmental spills or things of that nature, and you know are able to pick something up in a couple of days because they're doing either continuous monitoring or they've got a regular schedule where they're picking things up, then to me that seems like an opportunity to be able to offer, you know, a reduction in penalties that would be similar, if not more, than what was indicated. On the other side of that, if you've got an operator that, you know, does not routinely utilize best management practices or is not paying attention to what's going on, and they have a spill that, you know, they may have self-reported because they noticed it, but it's been 160 days or something like that, then that may not warrant, you know, a 35%, you know, penalty reduction. And so I think that discretion, you know, makes sense to me. And I think that also encourages, you know, best management practices by operators, which I know, you know, the good operators are already utilizing those best management practices anyway. And so that's kind of the way that I'm looking at that. I was curious about your thoughts on that.
On the first point, Commissioner Messner, you're right. We don't know how the overlay between the local public hearing is going to work with the separate local government's permitting process. So you are right. It could be complementary, and I think it could be confusing depending on how things go. And that's why we just brought it to the Commission's attention.
And Commissioner Messner, on your second point, I think that the 35% minimum is just a guidepost. You can go above that, but if to your statement, if you didn't see it, or maybe if you didn't have best management practices that would cover it, I would say that you wouldn't be entitled to the protections of self-disclosure anyway. Under Rule 525, there's certain things that you need to do to ensure that you can avail yourself of self-disclosure, and which would mean quick recognition and remediation. So if it took 165 days to discover it, I would say that you probably couldn't self-disclose that under the commission rules anyway.
Other questions, commissioners, for this panel? All right, I've got I don't know if it's a question or if it's a heads up that I'd like to speak to the lawyers about. I see we have Neslin and Mark Matthews and Mr. Martin on the phone. And it gets to something that you've not testified about, but it's something that I'm going to ask Attorney General Davenport to look into for me. And this has to do with responsible parties, the limitations or non-limitations that may exist within the Act, the issues around the fact that as director, I found transfers occurring and then we end up with messes and new operators are not obliged to clean up, just sort of around this whole thing. So it's going to get to the 200 series as well. It's here at the 500 series and 526. And I'm going to have our Attorney General Davenport look into whether via a acceptance of a transfer by the commission, the commission can ensure that problems associated with that asset can be cleaned up by the successor in interest. So I'm just giving you guys a heads up that that's something that I want to be explored by the commission's lawyers and staff. I think it's an important topic. It raises its head a little bit here under 526, and it's going to raise its head in transfer of operatorship. If you want to speak to it now, you can. We can wait and talk about it at the 200 series. but it is an issue that I would like us to all focus in on. I don't know that I do not have the answer to it, but I think it's a subject matter that should be discussed amongst us during this rulemaking. So heads up.
I would only say that there certainly seems to be a tension between how responsible party is defined by statute and by Rule 526, and how the term responsible party isn't used in the 200 and 900 series, and yet liability is being assigned for a number of different aspects to the operator. So I recognize that tension. And I agree that it needs to be addressed.
Good. Well, we're starting on the right spot, that we agree that we should look into the issue and see if we can figure out a solution that's workable for operators and industry and allows for that tension to be addressed. So thank you. Other further questions for the panel? Attorney General Davenport, I guess I've now given you my direction. Do you have any questions about that? We can obviously talk offline, but I wanted just to set the stage for this discussion on this issue.
I don't have any questions at this time. We'll get to work.
Thank you.
Thanks.
Great. Thank you, panel, for your presentation today. Thank you for answering some good questions from commissioners. We will let this panel zoom away, and we will bring on the next panel, which is 350 Colorado Group, Physicians for Social Responsibility, Lookout Alliance, Wild Earth Guardians, and Colorado Environmental Advocates. And I will suggest to the world at large that we're 30 seconds ahead of time.
Ms. Lario, this is Ms. Larson. I'm just checking it. It appears that 3 other members of your panel, Stephanie Mallon, Patricia Nelson, and Christine Nyholm, are currently not in the meeting. Will they be joining you?
I believe so. I will check in right now and see where everybody is. I know we met earlier and we have our PowerPoint ready, so I will check in.
Okay.
Oh,
and Ms. Larson, there's a chat that Ms. Micah Parkin is going to be screen sharing, but I don't see that we found her either.
Okay, I will get Ms. Parkin in.
And sorry, this is Catherine Merlin. We're also looking for Barbara Donachi.
Thank you. We just allowed Ms. Donachi in.
Okay.
So I think we're just missing Ms. Nyholm.
And we also need to, one of our other speakers is Tricia Nelson. Patricia Nelson.
I wonder, should I start, Micah?
Let's wait until we get everybody on the screen. Your time's not running, so.
All right, thank you. I'm glad you're ahead of time. That's great.
It's unbelievable.
Yeah, it is.
So unfortunately, we're still unable to locate either Ms. Nyholm or Ms. Nelson.
Ms. Nyholm will not be speaking.
Okay.
We're just waiting on Tricia Nelson, Patricia Nelson. And just wanted to let you know, I'll be screen sharing for the presentation, please.
Yeah,
Okay.
maybe, do you want to bring up the PowerPoint, Micah, while we're waiting?
Sure.
Doesn't hurt.
Do you know perhaps, is Ms. Nelson calling in?
Does
Oh,
she
you
have
got her? Looks like we got her.
And Ms. Larson, what is the time allotment for this panel?
So this panel has 5 minutes for their presentation.
Is that, do you agree with that, Ms. Parkin or Ms. Merlin? Okay.
Yeah.
Okay, well, it looks like we have the full panel in the house. So Ms. Donache, are you starting out for the panel?
Yes, I am. My name is Barbara Donakai. I have a master's degree in public health from the Colorado School of Public Health. And thank you very much for the opportunity to speak. I'm first introducing these common concerns on behalf of our 5 partner organizations that you can see here. The first one, the definition of standing is inconsistent with state APA, which will result in needless litigation. The draft rules do not include specific protective measures and guidance regarding disproportionately impacted communities. Draft rules provide less consideration to tribal governments than local governments in regard to notice, opportunity to object, and standing. And most importantly, a neutral commission really doesn't protect public health. I speak today on behalf of Dr. Stephanie Malin, who is unable to be here because she is currently hospitalized. In addition to prior testimony from Doctors Lisa McKenzie and Sandra Steingreber, outlining the many serious health impacts of exposure to fracking operations, Dr. Malin has provided research on psychosocial impacts on those living near fracking operations. She has found that members of the public living near these operations experience increased levels of stress and depression. Marginalized communities, such as those around Bella Romero Academy and various tribal communities, experience a greater sense of powerlessness, experience greater actual risk, and wield less political power. They bear the brunt of fracking impacts while experiencing the worst outcomes and the least economic benefit. They experience uncertainty around the risks involved, particularly with the rapid onset of oil and gas development in relation to the ever-emerging scientific evidence of long-term risks. Exclusion from the zoning and regulatory processes is a key example of systemic injustice. This extends to lack of access to useful translated information about the risk to public and environmental health in their communities. Industry clearly holds the power here. People who do not want fracking on or near their lands face complicated lease terms, lack of enforcement, and lack of legal resources. So thank you for your time. I'll now introduce Broomfield resident and mom, Lizzie Lario, who has a pre-recorded statement, but she is available after for questions. Thank you.
Thousands of hours working to protect my community from oil and gas. These thousands of hours have taken away from my family and my career.
Ms. Donachi, unfortunately, we are not able to hear.
Let's time out. We're not going to take time away from you. Can you restart the video and maybe turn it up a little bit?
We're working on that.
Okay, just take your time.
My name is Lizzie Lario. I've spent thousands of hours working to protect my community from oil and gas. These thousands of hours have taken me away from my family and my career. I've missed my daughter's softball games, family dinners, tucking my daughter in, and saying goodnight to my husband. There were some weeks I had to put everything second to oil and gas, including my job and my clients. If asked, I can tell you what it's like to spend those thousands of hours defending my and my community's rights in a system that, even with regulations and rules, is a setup for failure for the average Colorado resident. I can tell you what it's like to work so hard to protect your community, but never really get a fair shot, or sometimes even just a seat at the table. And I can tell you what it's like to have oil and gas move into my neighborhood. Thank you.
Thank you. Our next witness we're introducing is Patricia Nelson from Greeley, Colorado. Go ahead, Patricia.
My name is Patricia and I live in Greeley with my son Diego. He's a student at Bella Romero Academy, where one of the most egregious cases of environmental racism in Colorado has unfolded. In 2016, the COGCC permitted 24 wells less than 700 feet from our playground. This after Extraction Oil and Gas decided that 1,200 feet was too close to the playground at a predominantly white affluent school. Over 70% of our students qualify for free or reduced lunch versus 30% of students at Frontier Academy. The majority of our students are Latino and many of them only speak Spanish at home. Extraction took advantage of this language barrier. Considering how fracking can be complicated and secretive, they failed to communicate clearly with our school district. They tricked our administrators into thinking that there would be no activity while the children were in school. This was not the case. The vetting site was in flowback late last year, and this resulted in over 100 exceedances of benzene levels. Some of those occurrences were during school hours. I would like to reiterate recommended changes to the 500 rule series. We would like you to grant standing to all parties who qualify under APA to prevent needless litigation, provide sovereign tribal governments and other disproportionately impacted communities with notice, opportunity to object or request an ALA, and standing as other relevant and proximate local governments. Consider disproportionately impacted communities, even if the well pad is not within or immediately adjacent to the community or subject to an ALA, and provide enforceable standards to protect them. Do not attempt to act as a neutral arbiter between a multi-billion-dollar industry and the ordinary residents they threaten. Thank you for understanding that the rules are not a check-the-box exercise, and that that a company may comply with every letter of every rule and they can still be denied a permit.
Thanks, Patricia. That's our summary there. Do we have questions?
Okay, commissioners, it is our opportunity to ask questions. I'm sorry, I don't know how to pronounce your last name, but can you go back to the first slide you had? Or Ms. Parkin, I think you were doing the slides.
Yeah.
Yeah, that one.
Yeah.
So this may be a question for Ms. Merlin as the lawyer of the group, but Ms. Merlin, what we heard from Ms. Larson and Mr. Minor that the definition that we're using for standing is right out of the APA, but this slide says the definition of standing is inconsistent with state APA and will result in needless litigation. Can you amplify the concern there for us?
Thank you, Commissioner Robbins. My concern here with the definition is that while it's very close to the definition of standing from the APA for affected and aggrieved, there is a carve out for individuals or parties who need to show that they have an impact which is not shared by other members of the public. And it's that definition that we're concerned about, because while the commission is attempting to carve out people who claim climate change as their basis for standing, I'm afraid that this might actually carve out more than people who claim climate change as an impact, and might actually go farther. So for example, would a resident who is particularly affected by the regional haze or ozone pollution because of, for example, cardiovascular effects, would they be excluded? Would a parent like Patricia Nelson, whose child is a student at Bella Romero, would she qualify, or is that shared by members of the public too broadly? So the distinction between a member of the public who is affected, it's sort of undefined, that line there. And if there's really, what I see the potential for harm is anywhere there's daylight between the commission rules and the APA, you have a situation where someone might not qualify for standing to participate in a commission proceeding, but then might qualify still for standing to challenge it judicially after the fact. And that creates a lot of inefficiency where someone can't participate at the commission, but then qualifies for standing at the courts afterwards.
Do you have a suggested solution to the concern that you're expressing?
Well, I think that what I see the commission trying to do is trying to avoid standing based on climate change. And I would suggest that this concern itself might be somewhat misplaced. When someone qualifies for standing, they are then able to make other arguments that aren't related to the basis for their standing. So, for example, someone could come in on the basis of standing that they are very close to the well or proposed well, and then they could still go on to argue climate change impacts, even though those aren't the basis for their standing. So using standing to exclude arguments about climate change, I don't think will be effective. So my recommendation would be that the commission would simply incorporate by reference the Colorado APA and therefore eliminate that daylight. And then, you know, the climate change will have to play itself out in some other way other than through standing.
Commissioners, if you'll beg me just a bit. So Ms. Merlin, thank you for clarifying that. You know, you were a party to the original 500 series rulemaking, and I know that you wanted, you know, you had a lot of things to say there, and you didn't get a chance to testify here this afternoon. You only have 5 minutes. Is there anything else you'd like to point attention to for the commission that may or may not be within, you know, your statements? I just want to give you the opportunity to be heard.
I really appreciate that, Commissioner Robbins. I would like to thank the commission and the staff for all the work they've done on 500. I see vast improvements over the prior rules. I think my major remaining concerns are this, that it's wonderful that we're broadening standing to allow people to participate to protect themselves. But the problem that remains is that people still have to protect themselves. And this is a problem because we have a multi-billion-dollar industry and we have individuals who may be completely unfamiliar with oil and gas until they receive a notice. And that notice will say, it's coming to your neighborhood, here's how to participate. And that's just not enough for most regular residents to have a meaningful entrance into participation in this process. So, you know, the commission, we heard from Commissioner Messner, I believe on Wednesday, that it was his perspective that the commission was really tasked with being a neutral arbiter. And I respectfully disagree. I don't believe that the commission can be a neutral arbiter between these parties and fulfill its mandate to protect public health, safety, and welfare. If the commission really and truly believes that it must act as a neutral arbiter, then that is why I've proposed tasking staff with a position of acting as a public interest advocate, because folks like Lizzie and Trisha really shouldn't have to spend, you know, time that they should be spending with their kids fighting oil and gas. It's not their job and it's not their responsibility to have to work so hard to protect themselves and their community. That's really the commission's job now. So respectfully, I would ask that the commission really see itself as a challenger to industry to protect public health so that these folks can, you know, go spend time with their kids and rest assured that the commission actually is looking out to protect them. Thank you.
Thank you for that, and I appreciate this discussion. A couple of thoughts. One, you know, I firmly believe that staff is you know, to a certain extent, a public interest advocate. I worked with this staff for 18 months as director, and I saw the thorough engagement in implementing 181, and we're doing the rules now. And I thoroughly believe that once we get the rules in place, staff will fully ensure compliance with rules, which is ensuring protection of health, safety, welfare of the environment, and wildlife resources. That is the standard. And so I guess that's number one. And I would hope that on an as applied, basis, folks that you represent are not going to feel as much of a need to get involved, because this is going to happen on its own. So that's my perspective, just, as one member of this and having been involved in 181 for quite a while now. A second thought, and we've not said this word yet, but early on, I had folks reach out to me as director that one other way to sort of sort through the issues you're raising of people needing to advocate was the concept of an ombudsman. So having someone at the commission that can be here to help answer questions about public participation, to help steer people in the right direction so that they don't have to hire lawyers and things of that sort. Does that resonate at all? Have you given some thought to that, or would you mind giving some thought to that? It's not something that is part of rulemaking, but it might be something that is part of, quote, good idea for implementation as we turn the new rule set on. I'd love to hear your thoughts about that.
So thank you, Commissioner Robbins. As to your first point, I truly hope that we do see the staff acting as an advocate, and I have reason to hope that that will be the case. But I think we'll just have to see. As far as following the rules, we had heard earlier that the staff and the commission did not see this as a check the box exercise. So I hope I'm not misunderstanding that, but my understanding was that the commission saw that an operator could be within the rules and still not be sufficiently protective of public health, safety, and welfare. So my final response to that would just be the example that was given by Mimi Larson recently in the staff presentation to the 500 series regarding the disproportionately impacted communities engaging in the variance process. What I heard being said was that it was fully expected that disproportionately impacted communities would appear in the variance procedure to protect themselves. And that example was highly concerning, as it would appear to require disproportionately impacted communities to be actively monitoring for proposed variance requests, and then to come and actually advocate on their own behalfs. And this example was greatly concerning. So I hope that we can resolve that so that we can see that we're not actually putting it on disproportionately impacted communities in particular, but all Colorado residents to be actively monitoring the commission website for applications and proposals, and to proactively come and protect themselves, that wouldn't be the case. I think I'd like to hear what Tricia Nelson has to say about your proposal for the ombudsman. That was certainly in my proposed suggestions, but Tricia, as a member of a disproportionately impacted community, do you think that would have helped you? If you don't mind, Commissioner Robbins, me turning it over to her.
No, that's fine. I think this is a good discussion.
I'm not sure how much it would have helped me, given that, as far as I know, a lot of these operators are not required to send out notices in different languages and to send out notices to anybody who's not being directly impacted. And so for us, we were relying mostly on the communication with the school. And then ultimately what ended up happening is a lot of the parents were relying on me for information. And so, I became a source of information for my fellow community members. And so, there really wasn't anyone helping me other than other community members, and then ultimately became our attorneys when we filed the lawsuit. And so that was really, really hard for a really long time, and it still is.
Okay. Well, I appreciate that testimony, Ms. Nelson. And, you know, we're working on a suite of things here, and there's a lot of pieces to the puzzle, and we're working on the linguistic piece and getting notices out that, you know, can be understandable. And so I will, you know, continue.
And
Go ahead.
One of the suggestions that I made to one of the attorneys that I was working with that is party to the rulemaking as well was working in tandem with the school districts, because we are, every year we're required to fill out demographic paperwork. And so that information can be helpful in knowing what kind of, knowing the makeup of the disproportionately impacted communities, what they look like, who they are, what language they speak, because in my community we have had an influx of refugees, and so there's some people that don't speak English, they don't speak Spanish, and you know, even some of the languages are getting more and more it just the wide range. We have over 30 languages spoken in our school district alone, and a lot of them are monolingual speaking families at home.
Great, thank you very much. Commissioners, I beg your indulgence for, and I won't do this often in terms of just asking one witness to sort of tell us whatever else you want to know, but I just want you to know I've developed a lot of a good professional relationship with Ms. Merlin. I knew she had a lot of good things to say, and I wanted to give her that opportunity. So thank you for that. Thank you, panel, for allowing me to have this discussion. And at this point, I would ask other commissioners if they have questions for this panel. Okay, well, I must have asked all the right questions. Thank you guys so much. Really appreciate the panel. Appreciate your contribution to this discussion. I hope that you can see that we are attempting significant movement on 500 series, on standing. We may not have it precisely correct, but I think we're moving certainly in the right direction. Appreciate your contributions. And with that, we will allow Ms. Larson to Zoom you away, and we'll hear from you again later in the proceedings. I've been informed that our next panel of Adams 12 School District, that they're actually not going to be presenting. Is that right, Ms. Larson?
That is correct.
So that means if they're ready, we would move to the affiliated local government coalition, which includes that group, as well as the city of Aurora and the city of Thornton. I see we have Ms. Sanchez, maybe Ms. Pranos, Ms. Burke.
Ms. Burke, will Ms. Paranos be joining us this afternoon?
No, it's just me today. Okay. Let me turn my camera on. Right. So I'm just have a very brief, are we ready to go, or?
We've got Ms. Sanchez as well. Is Ms. Sanchez presenting? Or
I don't think so.
Backup.
I am not.
She's here for moral support. Just a very few things to say, some wonky ones for you about the affected persons, and then also about the penalties. Now, can I share my screen? Yes, I can. Okay. All right, can you see that?
Not yet.
Oh. What am I missing? There we go. Okay. How about now?
Yep.
Okay. So just a couple things. Primarily, I'm here to appreciate and support the draft as it stands today. And I'll start on the penalty issue. The industry party brought up the self-reporting automatic 35% reduction, and we support staff's removal of that and replacing it with the director's discretion. And just to cut to the chase, it's really what Commissioner Gonzalez said. Self-reporting is the right thing to do, and should not either need incentivizing, and certainly not, I mean, a 35% reduction is pretty significant. So I think the changing that to discretion based on the actual facts of the case was the right move, and we appreciate that very much. The other thing I'd like you to consider, Rule 525C4 carries over a reduction that's been in the rules, I think, for some time, that allows the commission to reduce the daily penalty amount if the violation goes on a long time. And it says in order to ensure that the total penalty is appropriate to the nature of the violation. But I'd submit to you that that's illogical, the way the structure of the rule is, and then also does send the wrong message. So yeah, I'm sure you've seen your own penalty chart, and it's carefully laid out based on the way in which, or the degree to which the particular rule violation is likely to impact public health, safety, welfare, environment, and then also by the significance of the violation itself. So then these numbers have all been arrived at by analysis by somebody in the past, and we'll assume that they are fitting for the moment. So for example, a minor violation of a rule that will not present a direct threat is only at $200 per day, whereas the most serious violation of the most directly impactful rules can be as much as $15,000 a day. So these have been decided upon as the daily penalty for these particular kinds of violations already. So it's illogical to say, and I'll just take the most extreme case, major violation of a very impactful rule. If $15,000 a day is the correct penalty for that, and then that violation continues on for 100 days, I'm not seeing the logic of why the daily penalty should reduce just because that violation went on for a very long time. And then also, as you know, your rules already give you discretion to consider mitigating and aggravating factors. So at the very least, I'd ask that you might ask your staff to explain why that makes sense. And then as far as, I will point out that you're making the rules to implement the statute and to regulate in a protective manner. They also are something that the public is aware of and pays attention to, and there's a message involved here where that if the violation goes on for a very long time, it sounds like you're going to get less and less strict with it the longer it goes on. I don't think that's what it means, but that's certainly what it sounds like. So I would just encourage you to take another look at that. We've proposed removing that provision 525C4 altogether, but at least to take another look would be our suggestion. And then as far as affected persons, I think you're going the right direction. I heard what Ms. Merlin said. I have a little bit of different take, but I think she has some good points. The main point I wanted to make is some of the industry groups had suggested that you add that the interest at stake is a legitimate interest, and they describe that as being how the APA defines it, but that's actually not perfectly accurate. The APA defines an aggrieved party as one with a legitimate interest, but that definition is specifically for the purpose of judicial review, not for the purpose of participating in the first place. So I'm just encourage you to leave the rule, the new draft rule as you have it drafted today. And Boulder County has had the experience where we were both the relevant local government and a mineral owner and still had our petition to participate be dismissed. So we're very pleased to see these changes. So that's all I've got. Happy to answer any questions.
Thank you, Ms. Burke. As I have asked for everybody, if you don't mind, would you email your slides to Ms. Larson? That way we'll have ready access to them during deliberations. And I sort of continue to remind folks that, and I guess I would tell the group that we zoomed away just a minute ago, if we could get your slides emailed as well, that just really is helpful. That way we're not sitting here, cranking down points that are being made.
Sure.
Thank you for that presentation. Commissioners, do we have questions for this panel? Commissioner McGowan.
Thank you, Mr. Chair. I'm wondering if someone from staff, because I actually talked to someone from staff about the penalty matrix. It's quite complicated. CDPHE does something similar where you look at the duration, the severity, and it all puts together a complete picture. And I think that intent also plays into that. And I'm just wondering if staff could maybe talk a little bit about the matrix and why it might be appropriate to reduce a penalty where the penalty has been happening for many days in a row, for example.
Could you, great, perfect.
Yep, Ms. Larson.
Yes, thank you. I'm happy to address the question, Commissioner McGowan. So the penalty matrix that is set forth in the rules and then also further expanded upon within our enforcement guidance seeks to ensure that the penalties assessed ultimately are fair. I understand I was not employed here at the Commission at the time that the penalty provisions were revised in statute, but those revisions significantly increase the maximum daily amount that could be assessed on a penalty, up to the $15,000 that you see in our rules. So noting that the way that the matrix itself is structured, it provides that the most serious penalties will be assessed the highest daily penalty, which is $15,000. And typically, the enforcement matters that we see that involve those Class 3, the most important and egregious violations, they're a very short duration. Typically, they're not beyond a year, far less than that. And so in most circumstances, those egregious matters, violations, will be assessed the full penalty. There's generally not a great reduction that comes into play. For those matters that, as Ms. Burke noted, can continue for quite some time, we usually see that in filings of paperwork, not to say or diminish the importance of timely filing forms and getting status reports and information into the Commission, but they are not necessarily matters that will rise to matters of public health, safety, welfare, and the environment. And so it's in those circumstances that the penalty matrix is helpful to calibrate the penalty to be consistent with the nature of the violation. So that has been the rationale behind that. And it's also important to note that sometimes staff wants to ensure that the penalty is something that can also be paid. There are circumstances where we have small operators that may be, if they're faced with a penalty of many millions for a paperwork violation, that is something they may not be able to pay, and they would be forced to look at no longer being able to operate those wells, and those wells could come into the orphan well program. So that's also a component of this. I hope that helps give a little background there.
Thank you, Ms. Larson.
Mr. Chair.
Yeah, Mr. Davenport.
Thank you. I agree with everything that Ms. Larson said. I just want to add that I think the duration matrix, the schedule in the rules are all an effort to comply with the statute 346121, which does require that the Commission promulgate rules to establish a penalty schedule appropriate to the nature of the violation. That's all I had.
Thank you for that clarification, Attorney General Davenport. Ms. McGowan, did you have any follow-up on that?
Only that, thank you, Mr. Chair. I think that if you just read it and you don't, I think you have to read the matrix and then combine it, or it has to be married to the actual violation. So we've seen some, as a new commissioner, I've been trying to understand the notices of alleged violations and trying to see how that matrix is being applied by staff. And I do think that you have to allow yourself some common sense leeway so that there is an appropriate penalty to hopefully change behavior and send a message, and also balance that out with how severe that penalty may have been or not have been, and the intent or the arbitrary or capriciousness or the bad behavior of the operator, etc. So it is, I think it's more complicated than just here's the matrix and these many days of violation, you automatically are going to get a deep discount. I see staff really looking at the situation and trying to use the matrix in an appropriate way. At least so far, that's what I've seen when I've asked.
Chair, if I may.
Yes, Director Murphy.
Thank you, Commissioner. I think that that's a really nice summary of the balance of these different pieces. And I think that there are two other pieces that are important. One, the matrix itself is entirely discretionary. And two, no matter what staff thinks is appropriate and works forward, every penalty that's imposed must come before this commission. And so if staff goes off the rails or is too conservative or too aggressive, like, this body has the opportunity to take a closer look or a harder look or a different look at the issue. And I think that that helps obviously guide all of our behavior as we're working through what an appropriate penalty is in a settlement.
Thank you, Director Murphy. Other questions from commissioners for this panel? Commissioner Messner.
Thank you, Mr. Chair. I don't have, I've got a question. It's actually for staff on this particular topic. And it's just out of curiosity for me. And I do think this is an important topic, and I would like to deliberate on this topic a little further, not at this time, but during commissioner deliberations. I guess I'm curious in the matrix here. So we've got a class 1, which is the paperwork or other ministerial rules, which is a violation that presents no direct risk, threat of harm to public health, safety, welfare, the environment, or wildlife resources. But then there's also a cross section there for a major, which is actual significant adverse impacts. And so that creates a 5,000. I'm just curious what instance what would that be?
Director Murphy, Ms. Larson.
Yeah, I worked on this rulemaking that implemented that table, and it feels like a lifetime ago right now, even though it was just a few short years. And I don't know that we've actually used kind of that first and last bucket very often. It would surprise me, but when you put together a chart, all of the boxes have a space, right? I don't know, Mimi, do you actually want to provide more substantive?
Sure. I can also say that, within our enforcement guidance document, we have sought to go through the rules as they currently exist and identify what class that they are. Excuse me. So, for instance, our current rule 206 reports is identified as a class 1. And if we were to look at the guidance policy, we provide that rule 323 is identified as a class 3 violation. So again, that is guidance, but that guidance has helped to guide the enforcement group in assessing what class of violation a rule violation should be.
Thank you.
Thank you, Commissioner Messner. Commissioner Nanjapa.
Thank you, Mr. Chair. Thank you, and I appreciate the staff's clarifications on this. I too, as Commissioner McGowan, have been trying to understand these penalty amounts and making sure that I understand how they're calculated. I wonder, just because since we're on this topic, and I agree also that it's important, and appreciate the comment too that it's based on the current rules, and that as these rules get revised, I guess those classifications would get applied potentially differently. But the one thing that came up when I was trying to understand this was the statute of limitations. And I wondered if either AAG Minor or AAG Davenport could just kind of comment on how that fits in. And And the point that I learned via Mimi was that, you know, the number of days counts from when the violation is discovered. And so I'm just trying to, I think both for the stakeholders, but also for us as we move forward, just would be good to have a little bit of that full picture.
Mr. Minor?
Thank you, Mr. Chair. I might try to phone a friend on this one and see if Mr. Davenport is able to respond. I'm not sure I can answer that off the top of my head.
Mr. Davenport.
I'll do my best. Commissioner Nanjapa, I think your question was about how the days of violation were calculated. Is that correct?
Yes, that's correct. I think there's been at least a couple of instances where the violation was greater than a year, but because of this statute of limitations, can only count from the beginning of, you know, the year after we discovered it to when the resolution occurred, I believe.
Sure. So the statute does provide, again, this is all of the enforcement action provisions are generally in 346121. And the statute does provide that there should be a penalty assessed for each day of violation. And that for violations other than reporting or minor operational violations, that the violation begins on the date the violation was discovered or should have been discovered through exercise of reasonable care and ends when the corrective action is commenced. The statute also does provide, and this is in a separate section, that there is a 1-year limitations period on any violation of the act. And so, and I don't, or speaking in a general sense, not to any specific resolution, I think most of what you have seen at this point is probably AOCs, which are settlement actions. And so, you know, essentially voluntary agreements between the operator and the staff to resolve a particular violation. And I think in those cases, the staff may have made a decision in order to resolve it, not necessarily to push the issue potentially, but those two principles would apply to any violation and any calculation of penalties.
Commissioner Nanjapa, does that is that responsive? Do you have further follow-up?
No, I think, and so, well, maybe just one quick clarification. So that limitation of 1 year is within the Oil and Gas Act? Or?
Yes, it is. It's 3460, 115, I believe. Yes, 3460, 115.
Thank you. Further questions for this panel or staff? Okay, seeing none. Thank you, affiliated local governments, Ms. Burke, Ms. Sanchez. Really appreciate the points you've made. Email us your PowerPoint, and we will look forward to hearing from you again later in these proceedings. And with that, I think we have our last panel of the day to bring to the House. That is Battlement Concerned Citizens, Conservation Colorado, Western Colorado Alliance, and Grand Valley Citizens Alliance. And my agenda says they desired 20 minutes. Mr. Sura, is that correct?
We're gonna give you a gift of 10 minutes. So we should, we'll be cutting that in half. I'm gonna share a screen right now. Hopefully you'll be able to see it, and let me know if it does show up.
It has showed up, and we'll take your gift of 10 minutes. And I see that we have Mr. Samuelson in the house. And then Ms. Robinson?
That's correct.
Is that it, or do you have others?
That's it.
Well, then take it away.
I appreciate that. Thank you. Thanks for this opportunity. As the last presenters on Friday afternoon, I want to thank you for your thoughtful engagement in the hearings this week. The outline of our presentation includes standing, Rule 507, variance process 502, and community engagement. First, to discuss standing, we're going to turn to Grand Valley Citizens Alliance President Leslie Robinson from Rifle, Colorado. Leslie?
Good afternoon, commissioners. Yes, thank God I'm one of the last speakers. But despite this late hour, I challenge you to think of the future. My name is Leslie Robinson. I'm a resident of Rifle, Colorado, and president of the Grand Valley Citizens Alliance, GVCA for short. GVCA has advocated for more equitable and fair COGCC standing rule for over 15 years. In my written testimony, I gave a brief history of the Department of Energy's experiment to use an underground nuclear bomb to release natural gas. Essentially nuclear fracking, but the gas was too radioactive to use. When an oil and gas company decided they wanted to drill closer to ground zero of the Rulemaking atomic bomb site, nearby residents and our GVCA members recoiled in horror and sued to stop the expansion. But not only for them, but also to protect the whole Colorado River Valley and drinking water for tens of millions downstream. But those residents did not have standing. The commission director at the time said all the COGCC rules told him to say yes. And there were no rules to allow him to say no. However, the proposed rules 503 and 507 will rightfully provide opportunity for people and communities, such as my own, that are impacted by oil and gas development to weigh in on the decision-making process. In particular, the definition of standing for affected persons provided in Rule 507.A appropriately allows anyone likely to be adversely affected by oil and gas project to become a party to the relevant COGCC proceedings. These rules have not received a lot of publicity, but they are incredibly important. Standing gives the public a meaningful opportunity to be heard by the decision makers, you, the commission. We know allowing the voices of impacted community members to be heard will improve the process and COGCC decisions. Thank you for considering these rules. Finally, on Wednesday, Garfield County officials noted they lack oil and gas regulations. Instead, oil and gas development in Garfield County is a use by right. So I'd like to point out that Garfield County's nearly 12,000 active gas wells receive no local government oversight or public input. That is why we need the same rules across the state. All Coloradans deserve the protections of Senate Bill 181. Your most important challenge in this rulemaking series, aside from authorizing and protecting the public through new standing regulations, is to give you, the COGCC, the ability to say no. Thank you very much.
Thank you, Leslie. We are proposing a very small change that would meet the commission's goal to make the Colorado Oil and Gas Conservation Commission more accessible to the public by allowing those who are noticed for oil and gas development plan to automatically qualify as affected persons. This would ensure that nearby residents will not be discouraged by having to meet a legal burden or feel they must hire an attorney in order to be heard by this commission. And now we're going to hear from Matt Samuelson.
Good afternoon, commissioners. I'm mindful of the hour, so I will be quick. We are recommending removing Rule 502A, the director variance process, or in the alternative, moving language from the statement of basis and purpose about limiting the director's ability to grant a variance to ministerial and procedural matters, moving that into the rule. You know, the current rule states that the director can grant a variance in writing without holding a hearing, but our feeling is that a director determined variance reflects the old COGCC, an agency where volunteer commissioners held a meeting roughly every 6 weeks and were greeted with a board packet that could exceed 1,000 pages. Now that we have a full-time professional commission, decisions on variance requests should be made by the commission with input from the director and staff. With time, resources, and capacity, the decision makers for the COGCC, you all, the commissioners, should determine whether to grant a variance. Now, we know the staff has worked hard on this particular provision and has proposed continuous revisions on Rule 502A through each iteration of the staff draft. And the most recent draft statement on basis and purpose suggests even more constraints to the rule in regards to the ministerial and procedural matters. Again, this is an improvement, but our preference is the more transparent, simpler solution of having the COGCC decision makers, the body that approved the rule, decide on variance requests in a public hearing. According to recent history of waiver requests, this should not be a heavy lift for the commissioners. The citizens groups will dive deeper in this detail on Monday, but from January 2014 to May 2019, they found an average of 3 waiver requests every 2 months. This responsibility will not overwhelm you all with work. You know, as an aside, I would think that perhaps the frequency of the reclamation variances suggests that the 100 series on reclamation needs to be examined as the problem and not the variance rule. And I can't believe I just suggested having another rulemaking. I apologize. You know, finally, the draft statement basic purpose states that the staff rejected earlier requests to eliminate director-led variance because it was inconsistent with the waiver abilities from some other Department of Natural Resource divisions, the Colorado Water Conservation Board, Colorado Parks and Wildlife, and the Reclamation Mine Safety Board. However, each of those boards is voluntary, unlike you all. You know, while you all reside beneath the DNR umbrella, the time and capacity you all have is significantly greater than those boards. Quickly, I'd like to turn to forced pooling. Similar to conversations you had this morning about community engagement, we are looking to expand access and understanding of the COGCC process to impacted Coloradans, but in this case, for those involved in forced pooling. You know, 2 years ago, the legislature passed a law requiring an offer to lease or participate in forced pooling to have a copy or a link to the agency-created brochure. In order to achieve its intended purpose, we think that this brochure needs to be provided in multiple languages. There are neighborhoods and communities throughout Colorado that contain a significant number of residents where English is not their first language. We requested that the brochure be provided in any language that is spoken by 5% or more of the population in that relevant census tract. Finally, you had an interesting conversation today. Yeah, it was this morning, about increasing commissioner engagement in local communities. The proposed local public hearing rule 511 will be an effective mechanism for the commissioners and staff to engage with community members, local governments, and operators on a proposed oil and gas development plan or a comprehensive area plan. We believe that it has the potential to improve communication and engagement statewide. Our one suggestion, and this is probably for the statement of basis and purpose, is that the best practices for holding a public meeting that have been discussed in relation to the community engagement plan would also be appropriate here. And finally, as a last aside, Commissioner Robbins, your concept around having an ombudsman is a conversation that we would all like to have with you as well. So we appreciate you bringing that up. And with that, we'll turn it back to you. Thank you very much for your time.
Thank you, Mr. Samuelson. On that second to last point, on the improved engagement on the local public forum, I missed it, but you said you wanted to put something in the statement of basis and purpose. What was that?
What we were looking for is that you had a conversation about there's best practices on how to hold community meetings. And it doesn't necessarily need to be in the rule, but that there would be some sort of consideration for, you know, time, place, translators, childcare, things of that nature. And so sort of the concept around how you hold a good meeting for the community engagement plans would work well with this particular rule as well.
Great.
And if I might add to that, local public forums should be local, and it should be in, you know, near the impacted area, and so any members of the public can easily attend.
Thank you.
Yeah.
I have a statement to Ms. Robinson, and then I'm going to open it up for questions. Ms. Robinson, thank you for your involvement. You've been involved at commission and trying to see standing get better for many years. The case you cited was in 2012, so you were involved several years before that. You remain here for us today, and I think it's really cool, and I'm glad that this commission is able to deliver on something that you think is important, that many people in the state of Colorado think is important. I think it's entirely consistent with 181. So thank you for your continued advocacy. And hopefully, as I mentioned to the previous panel, staff and us at the commission will, carry the torch and do good jobs here. And you now, I don't know where we're going to end up, but you and people like you will have standing, and you won't have to go to court to argue just whether you can argue. So again, thanks. Okay, having said that, do commissioners have questions or statements or otherwise to this panel? Commissioner Gonzalez.
Yeah, thank you. Earlier this afternoon, we heard from the industry group and a couple operators talking about variances. And what they talked about is that most often for one operator, they were driven by landowner requests to leave maintained or improved parts of their property intact. Another operator said that in many cases, the variances were for reclamation matters and oftentimes resulted in beneficial outcomes. I'm curious if there's any examples you can share with us of variances that have been granted that had adverse effects on public health, safety, welfare, the environment, and wildlife resources.
Mr. Samuelson, Mr. Sura.
Certainly, I'll take a shot at that. There is an opportunity for abuse. In an example that I know used to be the practice, and I think in more recent years staff has not allowed this to occur, but there are times when reclamation is simply waived for a price. The surface owner, is paid a price and receives some benefit, a financial benefit, and allows them to leave his or her property the way that they found it, or not fully reclaim that area after they plug and abandon a well. There are certainly other instances where we've seen waivers, variances requested when they couldn't get a waiver from a surface owner, and that's an example where you would certainly want to have a hearing, and it wouldn't be appropriate to have a director decide that was something that they wanted to take on.
Commissioner Gonzalez.
I hope that answered your question.
It did. Thank you.
Commissioner Gonzalez, is it okay if I suggest to the citizens group's attorney that he needs to be ready to answer that question too? It sounds like they've done some digging around on variances, and they're going to testify first thing Monday. So I just want to throw that out there. I think that's an excellent question and an excellent line of inquiry.
Yeah, and I think we want to get the right answer, right? So I think it's appropriate to put them on notice, and I'd love to hear some specific examples of where this has been abused, specifically in cases where it doesn't affect, where the current rule as drafted would implicate a negative outcome.
Mr. Freeman, you're put on notice. I see that you're listening. Others with questions for this panel? All right. Ms. McGowan, Commissioner McGowan.
No questions, but just last but not least, and thanks for hanging in there Friday at 4:46. Much appreciated.
Well, thank you.
Thank
You've
you.
done a wonderful job this week. Thank you.
Great. Thank you, panel, for hanging in with us. As I mentioned, as Commissioner McGowan mentioned, we will let you Zoom away, and if I can get staff to show back up on our panel. We are at the end of our first week's agenda. Yahoo. I suggest we be done and not move toward another panel at this point. I think we've done yeoman's work this week. We all deserve some days off, or we all deserve days to get ready for next week. So with that, I want to thank our stakeholders. There's still 93 of them on the line. That's impressive. Thank the folks that have presented to us this week. Thank staff. This is very, very important. Staff, you guys are killing it. You've been killing it for months. You've been killing it for a year and a half. The amount of rules that you've brought to us in the various iterations, always advancing the cause and always getting us to more consensus, is really, really tremendously helpful for all of us. So, you know, Colorado, you should be proud. We got a hell of a staff here, and they're doing a great job of helping all of us through difficult issues. So thank you, COGC staff. With that, I'd look for a motion to adjourn.
So moved.
Sorry, Mr. Chair.
Oh yeah, wait a minute. We can't adjourn because then we'll have to start all over.
Oh,
we look for a motion to adjourn until Monday, August 31st at 9 a.m. Is that where you were going, Mr. Davenport?
Thank you. Yep, thanks.
Oh, that would have been a nightmare.
I am motion to adjourn until Monday, August 31st. Is that what we said? At 9 a.m.
And do we have a second?
Second.
All those in favor signify by saying aye.
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 Good night, everybody.
Good night. Have a good weekend.
Have a good weekend.